The April 15th Texas Commission on Law Enforcement meeting is called to order. Ms. Moore, would you please do roll call of the commissioners, please?
Commissioner Kim Lamo.
Here.
Commissioner Justin West.
Here.
Commissioner Janet Atkins.
Here.
Commissioner Justin Berry.
Here.
Commissioner Connor Harvey.
Here.
Commissioner Sergio Sines.
Here.
Commissioner David Kreiner. Commissioner Jason Griffin. Commissioner Rita Watkins. We have a quorum.
Thank you, ma'am.
For a second. Good morning, everyone. I wanted to, or afternoon, take a moment of personal privilege and recognize our presiding officer today. Several weeks ago at the Texas Police Chiefs Association Conference, she was honored with a award called the Barbara Childress Trailblazer Award. It honors female police executives who demonstrate extraordinary leadership, innovation, and influence. And it's recognizing trailblazers that followed Barbara Childress, who was the first ever president of TPCA. So congratulations.
Thank you very much. Thank you. You did. I wanted to take the opportunity to welcome all of you that are here with us today in beautiful San Antonio. Being here in San Antonio is yet another example of our commitment to have our meetings across the state so that we can better connect with our regulated community and also with citizens throughout Texas. I'd like to thank all of you that are joining us online or that are watching it or who will watch it at some point later. Appreciate your time in doing that. I also wanted to take a moment to recognize the staff, because whenever we have a meeting in Austin, which is where TCOLE is based out of, yes, there is a lot of extra work to put those meetings on, but when you think about the logistics of having to put on a state agency public meeting out of town, this is an extraordinary amount of extra work that they have to put into it to make everything runs smoothly. So I wanted to thank all of the TCOLE staff. And if you will please stand up, we would like to recognize and thank you. And yes, there are people back in Austin to answer the phones and take care of business. But it shows the commitment or what it takes to pull off the meeting. And I know that there's also been a lot of behind the scenes work that takes place the weeks and months ahead of these meetings. So thank you very much. For those of you that tune in regularly, you have probably noticed that the commission might look a little bit different than it did the last meeting. So let me take a moment and the opportunity to introduce you to our three new TCOLE commissioners. We have Sheriff David Kreiner, who is the Sheriff of Midland County. He has over 30 years in state and local law enforcement. He also serves as the second vice president for the Sheriff's Association of Texas. If you get to know him, he's very active within his community, and I know, sir, that you will bring a breadth of experience to the commission, and we are happy that you're here. Thank you. Thank you for being willing to serve in this role. Second, we have Dr. Rita Watkins, who resides in College Station. She's self-employed as a licensed professional counselor and supervisor. She formerly served as the executive director of the Law Enforcement Management Institution of Texas. And one of the things, Dr. Watkins, that I'm personally excited about is your background in mental health. And as you are probably well aware, the commission has made a strong commitment to licensee wellness across the state, but mental health issues intersect our profession each and every day. So look forward to your perspective and your experience in that area. So welcome. And I also wanted to welcome Assistant Chief Jason Griffin, who is with the Department of Public Safety, and he has honorably served with the department for 24 years. He is currently over training operations, so this will be a great fit having you on the commission and bringing your perspective, training perspective and knowledge to the commission. He has served in many positions and divisions across DPS for the last 24 years, and we look forward to having you on the commission also, sir. Thank you. So if you could welcome our new commissioners. I also want to take the opportunity to thank our former commissioners, and we will do so more formally at the next meeting. But Jason Hester served for over 12 years. Sheriff Mike Griffiths came off the commission, and then Patricia Burris also served for 12 years. And Rita, if you don't know Patricia, somebody that we need to get you introduced to, because she was one of the strongest advocates for mental health that served on the commission. So that was a passion that she had. So I also want to thank the University of Texas at San Antonio for hosting us here today, and Chief Stephanie Schonborn. We appreciate the hospitality, and thank you for all of your work in getting this meeting set up. I need to recognize a special group of people across the state of Texas. Hopefully everyone knows that it is National Public Safety Telecommunicators Week this week. Our telecommunicators play such a critical role in safeguarding our communities and also keeping all of our law enforcement professionals safe. I think it's great that we have a whole week to celebrate them, although I would challenge each of us to make sure that we're celebrating them each and every day for the work that they do. They are, I think, Executive Director, you made the comment, they're kind of the unsung heroes in our profession. They're the behind the scenes that just make everything work, and they're our lifelines oftentimes. So we're just grateful for all the work that you, our telecommunicators, do, for your professionalism and your service. Thank you very, very much. And for those of you that are in law enforcement, and even if you're not, you know, I would hope that you would go back to your agencies or contact your agencies and show your appreciation. For those of you that may not, telecommunicators are our call takers and dispatchers, and they make everything work for us. So hopefully you will go back and share your thanks and gratefulness to them. So we have a busy agenda today, so we're going to go ahead and dive right in. Again, for our new commissioners, if you have a question or if there's something that may not make sense or that you don't quite understand, please speak up. Don't hesitate to speak up, and one of us can answer, or our general counsel will be happy to answer the question, or any of the staff here. So we are going to move on to agenda item number 4, which is the approval of the minutes from the February 12th meeting. Do we have a motion?
Motion that we move to accept the minutes for February 12th.
Could you?
Mic test. There we go. I make a motion that we move and accept the minutes from the February 12th, 2026 commission meeting.
I second it.
We have a motion and 2 seconds. All those in favor say aye. Aye. Any opposed, same sign. Motion passes. Agenda item number 5 is to discuss and take action to approve the recommendations for the Law Enforcement Achievement Awards, and we will move to Director Gretchen Grigsby for that.
Good afternoon, Commissioners. You have in your packet the nominations for the Texas Law Enforcement Achievement Awards, which, as you'll remember, are in the categories of Valor, Professional Achievement, and Public Service. By statute, we are limited to 20 for each of those categories. We often exceed the nominations, and we certainly did in the category of valor this year, and so we were capped at 20 of them. But I think you will find that they are the best and brightest that the state has to offer, and we are excited to recognize them. So the item before you, hopefully you've had a chance to look at those summaries that the team has put together, and what's before you is to approve them for their nominations. I would like to recognize the judging panel that helped us score these nominations. Sheriff Russ Authier of Parker County, Chief Anthony Boone of the Longview Police Department, Constable Leticia Vasquez of Bexar County Constable's Office Precinct 2, Officer Gabriel Candia of the El Paso Police Department, and a public member, Nick Atwood, out of Lubbock. They were kind enough to lend their time to reviewing these nominations and providing us those scores so that we can bring them to you for your approval. I would also like to mention the ceremony will be held in the House of Representatives chamber at the Capitol on June 26th, so we look forward to recognizing these nominees should you approve them.
Do we have a motion?
I make a motion that we move and accept the proposed recommendations for the Law Enforcement Achievement Awards.
Do we have we have a motion and we have a second. All those in favor say aye. Aye. Any opposed, same sign. Motion carries. We are going to skip agenda item number 6 and put that into the June meeting. Agenda item number 7 is to discuss and take action on commissioner subcommittee assignments and do commissioner elections. So let's talk for just a minute about the subcommittee assignments. Oftentimes we will appoint a subcommittee to address certain issues. For today, we're looking at the Budget Committee, and although the legislative session doesn't start for several more months, we have a lot of, as Brian can talk about, we have a lot of work and information that has to be submitted well before the session begins. Do we have a volunteer to chair that committee?
I'm happy to do it. I was on the budget committee last year, and I'm happy to serve in that capacity for this session.
Thank you very, very much. Appreciate that. So Connor will serve as the chair of that. Obviously, your liaison will be Brian, and of course, executive director will be involved in that very closely also. Do we have any other commissioners that would be interested in serving on the budget committee?
I will.
Okay.
Yeah.
So we've got Justin Berry. Anyone else that would like to serve on that committee?
I'd like to serve as well.
Okay. So we have our Connor and our 2 Justins.
Not confusing at all.
Okay, let's move on. I'm going to ask you to talk a little bit about the second one. And this is not going to be, this will be a committee that it will be more serving in the role of a liaison, a commissioner liaison to the committee that will be, they'll liaise with some TCOLE staff, but also additional members of a committee. So if you want to
Similar
talk a little
the
bit about it.
advisory committee, correct? So over the past couple months, we've been, my agency and then some others I've spoken with, been looking at firearms qualifications. And as TCOLE is the minimum standard bearer for what we do in law enforcement, we saw a need to address and maybe improve what our minimum standards look like. So the goal is to develop a advisory committee that's going to have a liaison from the commissioners that will work with staff and that advisory committee to develop more real world standards for basic law enforcement firearms proficiency and application to training, and as well as reporting back to TCOLE on that training. And so you want to do volunteer for the commissioner volunteer? So I'll volunteer.
I didn't understand what you said. I was
Oh.
gonna help out here.
Well, it's, and we could have more than one, right? Absolutely. I'd love to have multiple points of view. And Jana brings lots of experience as the head of an academy for years and years and years. So it'd be great to have you
Don't make me
guys.
too old, okay? Years and years and years.
Well, I mean, you didn't go to school. You actually just started the academy
Yeah.
as your
Sometimes I think so.
kindergarten. Very good. Well, thank you both for volunteering for that.
And I'd like to especially thank our new commissioner. Thank you very much. Okay, well, we'll move on to elections. We will have elections for, per statute. We need to elect a new assistant presiding officer and also a secretary for the commission. So let me open it up to nominations for someone to serve as the assistant presiding officer.
I nominate Justin West for Assistant Presiding Officer.
Second.
Okay. Do we have anyone else? Okay. All those in favor of Justin West serving as the Assistant Presiding Officer? All those in favor, say aye.
Aye.
Any opposed, same sign. Congratulations.
Thank
Okay. Do we have any nominations for secretary?
I'd like to nominate Justin Berry for secretary.
I guess I probably should have asked if y'all accept the nomination. My apologies.
That's not how this works.
I accept.
Do we have a second?
Sergio.
Oh, I'm sorry. Okay. Do we have anyone else? Any other nominations? Oh, we're making it easy. Okay. All those in favor of Justin Berry serving as secretary of the commission, please say aye.
Aye.
Any opposed, same sign. Well, congratulations. We now have a new assistant presiding officer and a new secretary. Are you sure you know what you volunteered for?
Sure.
Okay.
You want to take over now or?
So, okay, well, thank you for volunteering and being willing. Thank you for the nominations. Thank you for volunteering and being willing to serve in those roles. Appreciate it. We will move on to agenda item number 8, which is to discuss and take action on proceedings for revocation, suspension, and other disciplinary actions. And for that, we will move to or go to Assistant General Counsel Mark Duncan.
Madam Chair, if I may,
Yes, sir.
before Mark gets started, commissioners, he'll go into the specifics of each case, but I do want to reiterate for the benefit of those of us who have worked on the commission, who are new to the commission, and for members of the public and people watching on the live stream, the next several categories of information or for the commissioner's consideration are agreed items, whether it be agreed orders of suspension, agreed orders of resolution, agreed order of administrative penalties, or a penalties waiver. These are actions which were either set for the State Office of Administrative Hearings or went to the State Office of Administrative Hearings, but prior to reaching them or at some point once getting there, were settled in negotiations with the party, staff or executive director, and the other parties. As an overview, certainly Mark and the rest of the legal team will go into the specifics of each one of these cases as we go through them. But to give you a general idea, these are agreed orders which have gone through the negotiation process for your consideration today.
Good afternoon, commissioners. And for the first one here, we've got an agreed administrative penalties waiver from Kima PD. Slightly different than what he just said about all the rest. A waiver is actually after the legal case legal gets a case from enforcement, we send notice to the respondent in form of petition. Petition includes a waiver where somebody without really starting a case or fighting it can just agree to what's going on here. So in this case, respondent just signed the waiver. Kemah Police Department, located just on the coast, just southeast of Houston. They signed the waiver agreeing to pay $350 administrative penalty for failing to timely submit an F5 to a separating licensee. After the agency filed an F5 with TCOLE, the licensee reached out to us 2 months later saying they never received it. So the agency said they forgot. They had 7 days and they missed it. It's a procedural mistake, but obviously something that we take seriously so officers aren't mistakenly acting under the authority of their license. We recommend you approve the waiver for your consideration.
Do we have a motion?
I move we accept the waiver as recommended by legal.
Second.
We have a motion and a second. All those in favor say aye. Any opposed, same sign. Motion passes.
For Trinidad PD, this is an agreed order. We submitted the petition, they responded and began the case. And then we negotiated this settlement. From February 2024 through November 2024, Trinidad PD failed to obtain and review personnel records from previous law enforcement agencies for 8 licensees as required during the background investigation. Essentially didn't go to the agencies and read the personnel files. The executive director sought administrative penalty for those. There's a new chief. He's audited all his files. He's been very cooperative with us. So I negotiated with him a reduced administrative penalty and he signed the order for $1,000. We recommend acceptance of that order for your consideration.
Okay, I do have a question for you. You said that the chief has audited the remaining personnel files.
Standard practice for us when we catch something going on, we're like, look at everybody, go back for what the previous chief did, make sure there's nothing else going on. And he's changed the system. You know, I think they're working hard to make sure this doesn't happen again.
Okay, thank you. Do we have a motion?
One last question as well.
Oh, I'm sorry.
So this was, the penalty occurred under a previous chief, not the current chief.
Correct,
And the current chief has been very accommodating and working with y'all.
correct.
Sure. My next question for general counsel. Are we able to reduce the fee from 1,000 if we wanted to something else, even though this is agreed upon?
Certainly, we can discuss it and we would send it back out to the other party and see if they would agree to it. Obviously, if it's a reduced fee, I'm sure they would agree to it, but we would still have to take that procedural step to do so.
And if you look in your notebook, it's already reduced.
It's already been
make sure you knew.
reduced from 8,000 to 1,000. They've agreed to the 1,000, but it would be procedurally possible to do what you've talked about.
I'll just make a motion that we move to accept the agreed upon suspension as presented.
Second.
We have a motion and a second. All those in favor say aye. Aye. Any opposed, same sign. Motion carries.
Next, we have the large group, all the cadets from the College of the Mainland training, BPOC. So I know the header of this part says agreed suspensions. I mean, everything else you've seen and we've been bringing you is agreed suspensions. These are not orders of suspension. I just want to make that clear. For the College of the Mainland cases, they were cancellation cases, and we've settled for additional training to fulfill our mission of ensuring the people of Texas are served by highly trained and ethical law enforcement. In November 2022, respondents completed a BPOC, Basic Peace Officer course conducted by the Liberty County Sheriff's Office through a memorandum of understanding with College of the Mainland Law Enforcement Training Academy. The executive director determined that this BPOC was fundamentally inadequate in providing respondents with the minimum state training requirements and course content and rescinded all BPOC training credits submitted to TCOLE. As a result, the ED determined that respondents didn't meet minimum training standards for licensure and cancellation of the student's license was sought. They appealed the case. We set it for SOA. We went to mediation and reached this resolution. Respondents in the ED negotiated terms and conditions in lieu of cancellation. They signed the agreed orders, accepting to complete within 9 months the supplemental peace officer course, crisis intervention training, K-9 encounters, interacting with drivers deaf or hard of hearing, human trafficking, de-escalation tech, civilian interaction training, and alert level 1. The ED recommends acceptance of the agreed order requiring the above training to satisfy minimum state requirements for licensure in lieu of cancellation for your consideration.
Are there any questions?
Question for general counsel. For the motion, do we need to name all of the respondents?
You don't have to. You can reference the respondents that are listed in the agenda and in the packet.
Okay.
Absent questions, do we have a motion?
I move we accept the agreed orders as stated for the individuals who attended this BPOC as outlined in the agenda.
We have a-
Second.
We have a motion and 2 seconds. All those in favor say aye.
Aye.
Aye. Any opposed, same sign. We will now move to agreed orders of suspension with Assistant General Counsel Daniel Walker.
Good afternoon, folks. Moving on to the agreed orders of suspension. As Mr. Beecham just said, this is a case where a petition was sent out to a respondent, and the respondent answered that petition by requesting a hearing at SOA to challenge. Prior to the hearing, a modification was made to the terms of suspension. There was negotiation, and the terms were formally offered to the respondent in an agreed order. They then signed an agreed waiver, conditionally accepting the modified terms contingent on the commission issuing a corresponding agreed order. I will go through these one at a time. The first one is slightly unique, so it's going to take a little bit more explanation. The first one we have is John Chambers, peace officer with Indian Lake Police Department. So John Chambers was convicted or placed in community supervision for 14 counts of tampering with a governmental record, state jail felony. He was statutorily revoked for that felony conviction. He appealed this, and this appeal went to the 13th Court of Appeals, and the result of that appeal was a reduction to Class A misdemeanors as opposed to state jail felonies. So upon it being changed on appeal to Class A misdemeanors, the statutory revocation was rescinded. So the executive director negotiated a modified term of suspension. And so we recommend the acceptance of the agreed order suspending his license for 10 years, fully backdated, going to his original conviction date of January the 29th of 2016 and ending on January the 29th of 2026. So this agreed order of suspension is for your consideration.
Any questions? Okay, do we have a motion?
I make a motion that we move to accept the agreed order of suspension for John Chambers.
Second.
We have a motion and a second. All those in favor say aye. Aye. Any opposed, same sign. Motion carries.
Next individual, Sean Faison, was convicted or placed on community supervision for theft, $100 to $750, a Class B misdemeanor. After receiving mitigating evidence during an informal conference with the respondent, we offered and the respondent conditionally accepted a modified term of suspension. So we are recommending the acceptance of the agreed order suspending the respondent's license for 4 years, followed by a probated suspension of 6 years. This agreed order is for your consideration.
Any questions? Okay, do we have a motion?
I'll make a motion that we move to accept the presented agreed order of suspension for Sean Faison.
Second.
We have a motion and a second. All those in favor say aye. Aye.
Aye.
Any opposed, same sign. Motion carries.
Next, we have Jacob Goshner. He was convicted or placed on community supervision for obstructing a highway or other passageway, a Class B misdemeanor. After receiving mitigating evidence during an informal conference with the respondent, we offered and he conditionally accepted a modified term of suspension. We recommend the acceptance of the agreed order suspending the respondent's license for 2 years, backdating to the beginning of April 22nd of 2025, followed by a probated suspension of 8 years. This agreed order of suspension is for your consideration.
I have a question for this one. What was the mitigating evidence?
The mitigating evidence presented was the cooperation, the willingness to take responsibility, taking into account age, career stage, his record as a jailer with the Anderson County Sheriff's Office. So it was a sum total of looking at all the information there.
Any other questions? Okay, do we have a motion?
I'll make a motion that we move to accept the
presented agreed order of suspension for Jacob Gushner.
We have a motion and a second. All those in favor say aye. Aye.
Aye.
Any opposed, same sign. Motion carries.
Next, we have LaShawn Smith of the Saginaw Police Department. LaShawn Smith was convicted or placed on community supervision for driving while intoxicated, a Class B misdemeanor. And upon the review of the mitigating evidence in an informal conference, we offered and the respondent conditionally accepted a modified term of suspension. We recommend the acceptance of the agreed order, suspending the respondent's license for 5 years, followed by a probated suspension of 5 years. And this agreed order of suspension is for your consideration.
What was the mitigating evidence with this one?
The mitigating evidence presented in this one was the facts of the case. If the facts of the case were more egregious, there was less ownership and taking responsibility. And in looking at the sum total of the full packet, the career, everything related to this officer, this was the recommendation by the executive director.
Any other questions? Okay. Do we have a motion?
Make a motion that we move to accept the proposed agreed order of suspension as presented for LaShawn Smith.
Second.
We have a motion and a second. All those in favor say aye. Any opposed, same sign. And then we have an additional one that was originally in our packets. Are we not doing that today?
We're not doing that. I'm just making sure there's no question. This one's being passed for today for Emilio Thomas.
Okay, thank you. We will next move on to proposals for decision, and I'm going to ask our general counsel to spend a few minutes, especially since we have 3 new commissioners. If you could spend a couple of minutes providing some education.
Thank you, Madam Chair. Commissioners, you have before you the next sequence of actions for your consideration, as the Madam Chair said, are proposals for decisions. These are cases that have went through review at agency staff. They've been sent out to the particular licensee. The licensee has responded and requested a hearing. These cases have gone to the State Office of Administrative Hearings for a hearing. Hearing was conducted, and the result of that hearing was a proposal for decision for your consideration. Now, some of these proposals for decisions and have before you some post-decision exceptions or requests to the administrative law judge to change the proposal for decision. Those are part of the record for your consideration. Generally speaking, when you are looking at the proposals for decision, you have some general options. General options, of course, are number 1, you accept the proposal for decision as submitted by the administrative law judge for your consideration. Number 2, you can consider the proposal for decision, the entire record, and you can obviously consider the executive director and staff's exceptions or proposed order for your consideration instead of the proposal for decision, ultimate conclusion as it relates to sanction or whatever the case may be, depending on if whatever the reason for the change was. And the third is you can consider, and as in the past, sometimes the sanction has been changed that's different from perhaps even what the executive director or the administrative law judge has considered. Those are your general options when you're considering proposals for decisions. I believe we have either representatives or the respondents for all the cases that you have before you today. They'll have an opportunity to come up. Staff will speak on the exact behalf of executive director, speaking from their perspective, and you will have, as you see in your notebooks, the records before you to base your decision on. On that brief overview, does anyone have any questions or comments about anything we just covered? Madam Chair.
Okay. If you planned Yeah, if you plan to speak, we have comment cards. So please make sure that you fill that out for the TCOLE staff who currently is in possession of blank comment cards. Okay, we have some in the back. If you have not filled one out already, you will need to fill that out before you come up to speak. For those of you that are coming up to speak, there will be a 5-minute time limit for the respondent to state their case, and that's not 5 minutes per person, it's 5 minutes in total. So if you have 5 speakers, those 5 speakers have 5 minutes, not 5 minutes each, but a total of 5 minutes. For staff, you will have 5 minutes to provide a response. And if there's any type of rebuttal, that will be a 3-minute time limit. So we will.
It'll be staff that goes first. Staff.
Yeah, I'm sorry. Yes, I said that out of order. Staff will go first, then the respondent, and then potentially a staff rebuttal. So thank you for the correction, sir. Any questions of the commissioners? Just need to mess that up for you. Okay.
As a housekeeping note, Madam Chair, and for everyone speaking, there is a clock to the our left, your right, as you see it from the podium, on that side of the podium for reference for the speakers.
Okay. We are going to hear the first case, which is Chad W. Borland. And I believe our Assistant General Counsel, Mark Duncan, will be presenting that.
Good afternoon again, Commissioners. The Chad Borland case is a cancellation case for a Class A offense where the administrative law judge found for TCOLE. There is a matter of law that I'll be addressing today, however, a minor correction on the order. Minimum standards are the minimum. Smallest quantity possible, you cannot do less than the minimum. Treating minimum criminal standards as mandatory has always been the stance of this commission and was explicitly reiterated last May in TCOLE v. William Ramsey when this commission overturned a proposed order from the State Office of Administrative Hearings on this exact topic, misinterpreting our intent. TCOLE's minimum standards for enrollment and initial licensure, Rule 217(1)B on the screen in front of you, states that the commission shall issue a license to an applicant who meets the following standards. As the commission said in Ramsey, the rule's plain language affords no discretion to issue a license to a person that does not meet minimum standards. Your Ramsey order cites DPS v. Forsgard, where Texas courts looked at DPS's concealed handgun statutes shall issue language and found that had the legislature intended a person to receive a license despite not meeting eligibility requirements, the statute would have stated so. Likewise, TCOLE has no discretion to issue licenses when 217(1) standards are not met. This point is reiterated in 217(1) Part L, if we can scroll down to that. It states a person who fails to comply with the standards set forth in this section shall not accept the issuance of a license and shall not accept any appointment. There is no way to read that a person shall not accept a license consistent with TCOLE having discretion to grant licenses to people who don't meet minimum standards. Part L continues, if an application for licensure is found to be false or untrue, it's subject to cancellation. Cancellation is the remedy in this situation. When you apply for a license or even just sign an L1 for appointment, you attest that minimum standards are met. When that statement is untrue because you don't meet minimum standards, the rule requires cancellation. Here in this case, Chad Borland was placed on community supervision for Class A deadly conduct in 1998. It's a violation of 217(1)B4. We can scroll back up to that. In 2024, he sought to become a peace officer, but he didn't meet minimum standards because of that Class A misdemeanor. The administrative law judge recognized these facts and agrees that we can cancel his license. The may part is why I'm making this argument. ALJs are under the misconception that our minimum standards are discretionary when they are not. As this commission has already ruled in Ramsey, they are mandatory. The ALJ's confusion comes from treating TCOLE's denial and cancellation rule, 217.5, as authority to cancel in this case. 217.5 is a rule for, as you'll see in A, applications for license and reports for appointments. It's a paperwork rule for credentialing. It lists situations where the commission can deny or refuse those reports to the commission. If you look at A1, it's not whether you meet minimum standards, it's whether you've been reported to meet minimum standards. 2 is whether it has a signature. 3 is if it's incomplete. 4 is if the report is submitted by the correct person. The rule doesn't relate to eligibility qualifications in 217.1. 217.1 has its own cancellation clause, as we just saw in Part L, after the word shall not the word may in 217.5. Because the relief requested was recommended in the PFD, you don't have a proposed order in your notebook. We aren't changing the outcome here, but I do want to make a couple corrections of law. We are proposing that you adopt it as is, deleting conclusion of law 7, removing the 0.5C from the end of conclusion law 8, and changing the word may in conclusion of law 9 to must. TCOLE must cancel respondent's license. TCOLE must cancel. Oh, sorry, yeah. So we're removing conclusion of law 7, removing the very last part, the 0.5C, referencing the wrong rule from conclusion of law 8, and may to must in conclusion of law 9.
Okay. Yes. Okay. I would like to ask those of you that are not TCOLE staff that are coming up to speak, if you will please state your name and your affiliation with the case.
Chad Borland, representing myself.
Thank you, sir, for being here today.
Thank you. Members of the commission, my name is Chad Borland, and I appreciate the opportunity to speak before you today. I want to begin by acknowledging the administrative law judge's findings in this case. I understand that under the technical application of the rules, my prior deferred adjudication from the 1998 places me outside the minimum standards for licensure. I respect the finding, and I am not here to challenge the law of the commission's authority. What I am asking for is your discretion based off the full context of my situation. In 1998, when I was 21 years old, I was arrested for DWI. As part of that case, the charge was amended to a Class A misdemeanor. Not because of the underlying conduct changing, but solely so I could qualify for deferred adjudication, which was not available at the time for the Class B offenses in Randall County. I successfully completed the deferred adjudication and the case was dismissed. I was never convicted of any offense. At the time I applied for my peace officer license, I believed in good faith that my offense had been a Class B misdemeanor. I disclosed the arrest and I did not attempt to hide anything. There was no intent to mislead or provide any false information, only a misunderstanding about how the charge had been classified over 25 years ago. Since that time, I have lived a law-abiding life. For over 2 decades, I've had no further criminal history. I've worked, supported my family, and committed myself to being a productive member of society. The person I am today is not the 21-year-old who made that mistake. I pursued a career in law enforcement because I believe in the service, accountability, and protecting the public. I have worked to meet the standards expected of a peace officer, and I take the responsibility seriously. This case is not about recent misconduct, dishonesty, or a pattern of behavior. It is about a single incident from more than 25 years ago under unique circumstances where the classification of the charge was influenced by procedural limitations at the time. I fully understand the importance of maintaining public trust in the integrity of the profession. I stand before you accepting responsibility for my past, but also asking that you consider my entire record, my conduct since the time, and my commitment to serving honorably. I respectfully ask the commission to exercise its discretion and allow me to retain my peace officer's license. Thank you for your time and consideration.
And a brief rebuttal, commissioners. I just want to state I don't disagree with anything he said. I think we're here on the legal issue, and we believe that the minimum standards don't allow discretion. There has to be a line somewhere that we're drawing, and we believe that line is that you cannot have had a Class A offense on your record, that the minimum standards say shall not, and they require cancellation. And for that legal reasoning, we believe that's the right outcome here.
Madam Chair. I have a question for Mr. Duncan. What would be one remedy? What would be one method of relief from the minimum standards under TCOLE rules for a Class A misdemeanor?
I mean, are you referring to waiver?
Yes, sir.
Okay, so waiver is not something within SOA's discretion. SOA can't decide, well, this guy should have gotten a waiver, and waiver is not within the respondent's discretion. It's a procedure that this board has, and this board's decided comes from chief administrators. It comes from an agency that says they have a special need or some special reasoning to hire somebody despite that. It's a procedure outside of these rules. It doesn't mean that you're discretionary to waive the minimum standards. It means once a separate procedure called a waiver procedure is brought by a chief admin, they come to you at a board meeting, not related to all the legal SOA issues, and they ask for the board in that situation through the waiver process to ignore the rule. It's not really a discretionary rule issue. It's just a separate process.
Thank you.
Okay. For the commissioners, do you have questions for either Mr. Duncan or Mr. Borland or of any other TCOLE staff?
I have a question. And I don't know if this is appropriate for TCOLE staff or for the respondent, but does anyone know if the waiver process has been started by any chance in conjunction with this PFD?
We have not received a request from a chief administrator for a waiver for this individual. And again, the licensee cannot get their own waiver. Only a chief administrator, a sheriff, a chief, or a constable can get that waiver. And no one has come to us asking for a waiver on his behalf.
The licensee is able to go to their chief administrator to request that chief administrator's consideration for it.
They could.
Sure.
If a chief or a sheriff or someone was willing to carry that and approach us, certainly something we would look at and consider.
Okay, thank you. And have you done that process yet, sir?
Sir.
You have tried. Okay. All right, thank you.
So my understanding is that the charge here was pleaded up for a more favorable probation. Is that correct? That the lesser charge would have been a more severe punishment, but it was pleaded up for a more favorable probation?
It was amended, yes, because at the time in Randall County, they didn't offer probation for Class B. So the option I had would have been that, but at the time, I just heard probation and just took it. I didn't realize at the time, circumstances permitting, that I was pleading up to a Class A at the time.
And I think I had read that you had talked to a lawyer and they had advised you, and they hadn't mentioned the consequence of pleading up to a future law enforcement career or anything. Is that right? Or did you not talk to a lawyer about this?
I did not talk to a lawyer, no.
My thought is that it's unfortunate that taking the higher offense level, a Class A, was the only option with probation, but I think it's still a conviction on your record, or it's ultimately, what you pleaded guilty to. And so the result of allowing for a license despite that is in a sense having your cake and eating it too. It's, I pled this way so I can get the favorable probation, since I couldn't get it with the lesser one, but I don't have the consequences either. And not necessarily that you're projecting, 25 whatever amount of years into the future to arrange things to think like that. But I think that's in essence what it would be, is like having your cake and eating it too, on both. And it's unfortunate that the consequences all the way down the road. I think I was 4 years old when I read this conviction happened. So it's been a long time, but I think I don't think it qualifies. I think the executive director's right is to the commission. That's my thought.
Any other comments or questions?
I do want to ask Mr. Borland a question. You said you've tried multiple times for waiver. What does that mean?
So I tried with Westworth Village, Granbury PD, reached out to Hood County Sheriff's Department. And the waiver just wasn't something they were interested in pursuing at the time. So.
Okay.
Any other comments or questions? Okay. Do we have a motion in this case?
Yeah, I will attempt this with the changes. I move we accept the recommendations from the executive director with the changes of removing conclusion of law number 7, removing conclusion law number 8.5C, and changing may to must in conclusion of law number 9. Correct?
That's correct.
Okay, we have a motion and we have a second. Melissa, we're going to do a roll call vote, top down, please.
Commissioner Kim Lamo,
Yes.
Commissioner Justin West,
Yes.
Commissioner Janet Atkins,
Yes.
Commissioner Justin Berry,
Yes.
Commissioner Connor Harvey,
Yes.
Commissioner Sergio Sines.
Yes.
Commissioner David Kreiner,
Yes.
Commissioner Jason Griffin,
Yes.
Commissioner Rita Watt. It's unanimous, motion passes.
Okay, thank you, ma'am. Mr. Borland, my apologies. I know that the outcome is not what you had hoped for. I think we all very much appreciate you taking the time to be here today. I want to personally thank you for continuing to want to serve in the profession. The waiver option is still there. I can only speak as a chief administrator. Of how many people within the profession view the conviction and the public trust risk of, of asking for a waiver. But that certainly doesn't mean that there might not be a chief administrator that is willing to go through that process with you. So I guess my suggestion would be either, continue to make application with different agencies, or maybe potentially looking at different areas within the profession where you may be willing to serve. A lot of times in our profession, it's like I spoke about just a little bit ago. People see the face of the profession of that person in uniform, a police officer. But there are so many other positions within the profession that are equally as important and equally as vital as our police officers, like we talked about with the telecommunicators. Now, they're licensed too, so we do have that hurdle. But there's a lot of other positions within the profession that, if you truly want to serve your community, I would encourage you to potentially reach out to an agency. And even if a chief administrator isn't willing to come forward with a waiver, they may be willing to hire you in another capacity. So that might be another option for you to explore. But I do appreciate, your continued interest in the profession. And thank you for being here today. Okay, we are going to move on to Thomas A. Santillana. And we'll continue with Assistant General Counsel Mark Duncan.
And Commissioners, Thomas Santiana is the exact same case as the previous one you just heard. Some of you remember respondent from the December commission meeting. At that meeting, he requested a waiver of our rules to allow him to be a peace officer despite a 2001 judgment against him for a Class A assault involving family violence. This commission ultimately unanimously denied that request for waiver. Unlike the commission during the waiver process, SOA does not have authority to waive TCOLE's rules. This case was abated briefly during the SOA case to allow the waiver procedure that you heard. After the commission denied the waiver, the case was sent back to SOA where the ALJ issued the PFD before you now. Having failed to obtain a waiver, respondent's criminal history makes him ineligible, and his license must now be canceled for all the reasons stated in the Borland case. Opposing counsel wrote a letter on page 320 of your packet in the notebook. This letter relates to the waiver process you already denied in December. It's not relevant to today's case and the SOA case. We're not rehearing the waiver issue today. This is just finalizing the proposal, the PFD, and the order that you have in front of you. Again, same minimum standard rules. The ALJ has the same misinterpretation, believing that TCOLE has discretion and whether to enforce our minimum standards. We don't. Both a Class A offense and a family offense are absolute bars to licensure. As you can see in your notebook on page 11, we are recommending changes to conclusions of law 7, 10, and 12 through 14 to be amended to reflect the mandatory nature of minimum standards, and therefore that respondent's license must be canceled.
Mark,
Yes.
what are those requested changes, executive director's requested changes again?
Conclusions of law 7, 10, 12, 13, and 14. Do you want me to read what they are?
7, 10, 12, 13, 14?
Correct.
Thank you.
It's actually on the recommendation.
Yes, sir. Thank you for being here. If you would please state your name and your relationship to the case, please.
Thank you, ma'am, and thank you for your time this afternoon, Commission. My name is Chase McCullough. I work with CLEAT, and my colleague's name, Kathy Reyes, has appeared on some of these documents. I'm here in her stead, so I appreciate your attention to that. As Mark said, this case is similar to some degree as the previous set of facts. It should be noted that the ALJ in this case did recommend that this commission exercise its discretion in order to not cancel this license. I believe that though Mark indicated that this is not a form necessarily to address the waiver, it is noteworthy that the contents of that letter addresses some of the issues that were presented during that meeting. And I would request that y'all do review the materials that were sent in on behalf of Mr. Santiana, excuse me. In the course and scope of Mr. Santiana's application for licensure, he went through BPOC, and throughout the time that he was seeking licensure, he made multiple communications with TCOLE requesting clarification as to whether or not he was eligible for licensure. Time and time again, despite regular disclosure of the circumstances that are now at issue today, TCOLE continued to respond time and time again that he was eligible for licensure and that he could serve as a peace officer in the state of Texas. I want it to be clear that he continued, and the SOA judge continued to find that he was transparent, he was straightforward, and made it known at all applicable times that he had taken this deal to have this deferred adjudication to resolve the allegations against him from about 25 years ago. Throughout the course of his career, since TCOLE continuously approved him and told him that it was acceptable for him to be licensed and to serve as a peace officer, Mr. Santiana has had an exemplary career. He has promoted all the way up to the rank of lieutenant. In the SOA hearing, he had numerous letters of recommendation speaking on his behalf by other law enforcement members in his community that spoke to his integrity and the benefit that he provides to the members of his community serving in his role as a peace officer. Even here today, law enforcement officials have come to be present. We have a limited amount of time So I'll be speaking on his behalf, but I believe the Waller County Sheriff and Chief Deputy, as well as a DPS trooper, came in person to support him because they recognize the benefits that he's provided to his community. I would urge this commission to exercise its discretion based on the principles of estoppel. Specifically, there was a 2025 Texas Supreme Court case that I believe is relevant to this matter. The Supreme Court case number is 23-0842 PTD Holdings v. the City of Dallas and the Board of Adjustment of the City of Dallas. In that case, the facts are very pertinent to our situation here because a government entity continued to represent to the plaintiff in that case that despite having access to all of the knowledge in order to make a determination based on their rules, they continued to rubber stamp, continued to give clearance to the plaintiff to the point that they proceeded in their actions and would be subject to great detriment because of their reliance on the municipal government in that case. Similarly here, TCOLE has time and time again told Mr. Santiana that he is eligible for licensure. He has put time and effort into building his career, serving his community, and now that TCOLE is seeking to revoke his license, that is very much to his detriment. Because of his continued transparency with this agency, again, we request that you follow the ruling of the ALJ and exercise your discretion and permit Mr. Santiana to retain his license. Thank you very much.
Commissioners, but for my rebuttal, I think the process needs to be explained, and this is a lot of what you'll see the ALJ got wrong here. People think that TCOLE is approving somebody over and over in these processes, but we're not doing background checks on the officers that apply to agencies. We rely greatly on agencies themselves to perform proper background checks. When they don't do it right, they submit us paperwork and they say, we think it's correct. And if we don't have the paperwork we need to show anything's wrong, our approval is just a rubber stamp on what we have. We're not doing the whole process and checking the background and seeing his criminal history and reading his PHS. So it's the ALJs and sometimes, and the way it was phrased here is like TCOLE's approved him over and over. We haven't. We say based on the information you've submitted, he is okay to be appointed. That's what the L1 process is. It's not all the licensees go through the background through TCOLE. So we are seeing in these cases where people get approved and then we catch them later, which is what these cases are in front of you, that at some point we're catching them. Ratback's catching up. They apply to another agency and that agency notices it. It's frequently that the agency is missing it, the first or second agency, and that when we finally look into it and we get the right documents, we can tell what the standards are and that this guy's not eligible. And so I don't think there's a TCOLE mess up over and over. You know, we kept approving him argument here. I mean, the L1 form is not us doing a background and saying this guy's good. It's us saying you've sent us the paperwork and we aren't the agency that does the full background. So it's agencies are making mistakes and we're cleaning up in situations like this.
Do we have any questions for either person?
One question for Mr. Duncan. This falls on what you were just saying. So what we saw in December, we saw the case in a waiver packet versus PFD packet with the ALJ saying that TCOLE has continued to approve the licensure and we depend on the agencies that provide the documentation, like say the L1. At what point was this brought to TCOLE's attention? How did we figure that out? Because I think I know the answer, but I'd like you to.
Yeah, let me grab the.
I can help with that if you'd like.
Yeah. Go ahead, TJ.
He applied with a larger agency who discovered it in the background, and then they reported it to us as a concern for the exact reason he described. Sometimes someone gets appointed with multiple agencies and they start to rely on the fact they were previously approved and assume that this past criminal case must be okay because they got another appointment, and the mistaken belief that TCOLE has approved them at some point. This one is unusual in that we responded to a request for an academy that sent us a request, and we did review his background very early in the process. I think this is fundamentally different than what he described in Dallas because we didn't have the information available to us. Harris County did not report the arrest. It did not appear on his criminal history. And the academy did not disclose to us that he had told them he had the arrest. So the information we reviewed, criminal history showed no arrest. We couldn't see anything at that time. He told them about it, and they're obligated to review those documents and determine whether or not it's a disqualifier. They failed. We didn't have the information available to us at the time.
So the bottom line is finally an agency caught it and TCOLE was made aware. So then TCOLE didn't approve as the LJ. So this counters what the LJ has said. Is that
Correct. And it's in the record, the letter that they rely on where we said it was okay. I mean, the letter states based on the information provided, and they did not provide us the criminal background and then ask us. We didn't have it until the reported by the later agency. And then once we did have the criminal background, we never said this is okay. We proceeded with this case.
Thank you.
I would just like to indicate that TCOLE asserting that they don't review PHSs is not a reasonable argument for asserting that they did not have the information. If he continuously provides the information to every agency that he applies to, and they continue to do the background check, I think that at some point TCOLE should acknowledge that if they have the information, if they receive the PHSs, regardless of whether they review them or not, them having the documentation does not support an inference that they were ignorant of that information. It simply supports that they did not review the information that they had perfectly capable access to. I would also indicate that in June 2025, Mr. Santiana received an electronic fast form from TCOLE indicating he was eligible to enroll per cites 215.23. So I believe that it has been consistently notified to TCOLE between his self-admissions to TCOLE and to the academy and the agencies he's applied to. This information has not been concealed. It's been made readily available at every step of the way.
Okay, so two questions in for Mark and TJ. You guys can answer this. The first one is the letter that informed you could be enrolled in the academy is fine. Did we send that out?
In this case, there was a letter where TCOLE said that the criminal background check was good because what he's talking about, the PHS and the criminal documents, we don't have those. The agencies have those, right, during the appointment process. We sent that out from a request from them, but they didn't send the request with the criminal history. They asked us and we said, based on the documents provided, they didn't provide us criminal history at the time. So we didn't have it when we approved that.
All right, so my second question is, based on what Mr. McCullough just stated, TCOLE can review every PHS. Do we have staffing to review 100,000 personal history statements?
No, we don't. And that's the way our system is structured, is the agencies are responsible for reviewing that. They keep the documentation. So when we get in this situation, we can review what they did. They have the obligation to determine whether or not they meet the minimum standard. The way we help in this particular case is generally with the college academies that don't have the authority to run criminal histories. So we do that small section for them and tell them the results of the criminal history search, but they're required to consider that in the context of all the information that they have before them. So the wording on the one he had that's under my team now is much clearer, is that we're telling you they are not disqualified based on the results of the criminal history. I agree. Mr. Santiana has disclosed it all along. I'm not accusing him of lying. I think he told them there, and I think the form that we sent them was less clear than the one now. But in the end, it all comes down to the simple fact is all we were doing was reviewing the criminal history, which showed no record of an arrest because it had not been reported at the time that we reviewed that record.
Okay, thank you.
I have a quick question on that note then. So TCOLE ran the CCH for that agency because they didn't have the authority or ability to do so. And so we sent it to their background investigator. So in that same argument we're making now, how did that background investigator know to go look at another agency where the arrest was made? I mean, he's reported it, so I guess the investigator would go to the arresting agency. But is that not something we would also look into as part of the CCH thing as well? That we're looking into, hey, he was arrested here just in his PHS. Is there a reason why we didn't go pull those records for them?
Is this the one where the criminal history was incorrect? Because you're saying it wasn't reported, the arrest. So we only did the CCH check.
Mhm.
So we don't have anything. An agency looking at his PHS, knowing this offense is there, might know that the CCH check is
So y'all never
incorrect.
had the PHS, y'all just ran the CCH, didn't have the PHS at the time. So the agency that was in charge of the background, they had that disclosure in their PHS. Is that
Yeah.
correct?
And I'm going off memory, but I'm pretty confident. He first applied at University of Houston downtown, I think, attended that academy. During the academy, there was discussion about his criminal arrest, and it was a disqualifier, and he was expelled from that academy. He then applied with Lone Star, went through the process again. In both cases, he did put it on his PHS. We do several hundred criminal histories for those college-based academies. If they don't have a criminal history, then we don't go to the academy and look at the PHS. It's up to them to review that and determine if there are arrests on there and what the disposition of those are. Colin can probably answer more to it, but they don't necessarily have dedicated background investigators. A lot of times it's the training coordinator who reviews it. I've seen some where they have 5 or 6 arrests that were all dismissed. And so the question is, are you still going to accept them into your academy? They're not disqualified by rule, but is that someone that you consider an eligible candidate? So they do have an obligation to review that before and make the decision on whether or not they would allow them to enroll in their academy.
Okay. Yeah, cause I'm not gonna lie, like this whole circumstance is just a lot of failures of a lot of different agencies and entities at work that set this guy up for failure. You know, my 2 cents and I see this is we have our minimums. It clearly states he was ineligible at the time. It clearly states that. But the failures of a lot of others along the way, and you know, I'm gonna admonish us a little bit. A month after we sent him his suspension letter, we sent him his is it intermediate or his advanced peace officer certificate? I mean, that's not a good look on us for doing something like that either. You know, I think it sounds like means the mistakes and the poor choices he made a long time ago. It's a really bad decision, but those consequences ripple, and these are part of those ripples of that decision back in that day. But I do think I would like to explore more and have more conversations offline later on about this process to understand it better, so we can make sure that other people that are applying to this, because once you reach a certain age, it's really hard to get a second job. You know, when you think you're doing anything right, you're disclosing it, you're doing everything you're supposed to do. People are telling you along the way, do this, do that. Oh, don't mark this, don't mark that. And you're just going with what the people are telling you to do because those are the hiring agencies. There's a lot of failures along the way that led us to this meeting right now. And I it just doesn't sit right with me, what's happened to this person. But I do agree that our minimums are what they are. I do think the ALJ judge has gotten it wrong in this case. But I do think there are some other systemic things that we really need to look at to try to shore up along the way, especially with those hiring agencies and some of the directions they gave.
Mark, would you just briefly take us back to really the foundation of this and talk for just a moment about the offense that this is really at the heart of
Yeah,
this
I mean,
decision?
you probably remember from December. I mean, this is family violence. His girlfriend, who was the mother of his child at the time, he punched in the face and kicked into a closet. She sought a protective order. I mean, they have since, this is part of the waiver process, I think you remember, they have since, I think they've gotten married, and so she's with him still. But the offense was pretty serious. He pled guilty to a Class A assault for it, and it involved family violence. And that's, as I noted, that's 2 disqualifiers.
Is it possible to hear more about the estoppel argument and your theory about why equitable estoppel under PDT would apply here?
Certainly. So while I do hear TCOLE's continued argument that even though the PHS is a TCOLE document, we don't allocate the resources to review these things. Even if we go and audit agencies, if we look over it, it is what it is, which seems to be the case in this factor that this PHS is filled in correctly for each agency that he applied to. He continues to disclose the elements of.
So can I ask you a question there
Yes, sir.
before we get on? So all those that he's disclosed and agencies know of the guilty plea and conviction, do those individuals disclosures apply into your equitable estoppel theory, or is it just that TCOLE has kind of known this whole time about the conviction?
I think that because there has been such regular and thorough disclosure of this, it creates a circumstance where TCOLE is thus creating a false representation of, yes, you are allowed to be licensed after these 9, nearly 10 years of permitting his licensure, with all of those representations made known. A licensee can't know that for sure that TCOLE just doesn't choose to look at their PHS. If he submits and consistently provides the information to the agencies that he's going to, they do their background checks with communication with TCOLE, he's reasonably under the impression that TCOLE is aware. And when TCOLE consistently sends him documentation saying, you are okay to be licensed, that gives him the impression that he may move forward. And at this point, if TCOLE is attempting to revoke his license, he has detrimentally relied upon TCOLE's representation. Again, this is 10 years we're talking about here, 10 years of exemplary police work.
So is your theory that TCOLE was aware of the conviction all along then, and not just the agencies that he submitted it to?
TCOLE has been constructively made aware of since the moment that he first disclosed this issue when he was submitting a PHS. The TCOLE rules state the PHS is a TCOLE document, and it is not a failure of the licensee if TCOLE elects not to review the PHS. The licensee submits the information that he submits, and TCOLE either says, yes, you are eligible for licensure, or no, you are not eligible for licensure. And in this case, when TCOLE comes back and says you are eligible for licensure, that's the information that Mr. Santiana has to rely on when pursuing a nearly decade-long career.
So how long has he been in law enforcement from that initial licensure till whatever suspension?
I believe it is a bit over 9 years. And again, he's risen to the rank of lieutenant with his agency at this point.
Was this pled anywhere, this estoppel argument, during the course of this case?
I believe that this was largely a function of the ALJ's decision to recommend that this board exercises its discretion. The ALJ specifically cited the, as Commissioner Berry brought up, the award of the advanced peace officer license and the ALJ's phraseology was quite pointed in that it is inconceivable that if there is such a great concern with the respondent holding a peace officer's license, the TCOLE would find it appropriate to award him with an advanced certificate while at the same time seeking to revoke the very same license. This equitable estoppel argument is fundamental to the arguments that were pled within the SOA hearing.
So the ALJ raised it then?
The ALJ acknowledged and agreed with arguments of the petitioner.
So going back, what was in the Supreme Court case that you discussed, or I'll look up the citation later. I'm curious, it was the city of Dallas?
The full citation is Supreme Court case number 23-0842, PTD Holdings Incorporated and Philip Thompson Homes Incorporated, doing business as Philip Thompson Custom Homes as petitioners via the city of Dallas and the Board of Adjustment of the city of Dallas as the respondents.
What was the interplay between sovereign immunity and estoppel in that case?
The interplay is that in reference to a case called Superwash from 198 Southwest 3rd at 774. In addition to when equitable estoppel is invoked against a municipality, the case must be an exceptional one in which justice requires estoppel and its application would not interfere with the exercise of governmental functions. And in this case, our argument is that there is not an interference with TCOLE's function by exercising its discretion in this case. And this is evidenced by the excellent work that Mr. Santiana has demonstrated, his lack of any meaningful discipline, and the fact that this incident happened nearly 25 years ago. And again, each agency that he has disclosed has continued to affirm, yes, you are able to proceed in this career, which has caused him to take action of such sort.
So I've got a few questions for both sides on this, if you want to take notes. But briefly, does it matter that PDT was a municipal case versus this is a state agency? That's number one. Number two, in PDT, it was a builder who was building a building, was 95% complete and had invested $1 million. And that was the detrimental reliance. I'm curious what the detrimental reliance theory or is not from both sides and how that compares to PDT. And then for the what PDT frames it as like an exception equitable estoppel, and asked whether justice requires the application and whether it will interfere with an important government function. So those are two kind of squishier elements at the end. What does justice require? Whether it will interfere with a government function. If you could both address those as well. So there's the municipal versus state, the detrimental reliance, and those two kind of last factors.
And if you don't mind me responding big picture to some of this, I think you've kind of dug in and hinted at some of the equity argued here is not fully accurate because people don't understand our systems, right? We're not looking at every appointment. We've gotten to the point that maybe that letter where we didn't have the criminal background but approved him, and maybe the certificate, which is automated and unrelated, those might fall into equity, but the rest of it was actually agencies themselves holding the paperwork that we never saw. So a lot of that, I think, doesn't even get into the argument, a lot of what's sounding like equity. But like the waiver issue, I want to remind you, SOA is not a court of general jurisdiction. They don't have jurisdiction over equity. It's not something they can rule. They have to look at the rules and the law and rule based on that.
I got to follow up on Commissioner Harvey's question. This is maybe an observation, but is there any such thing as detrimental reliance on something you shouldn't have had to begin with in the first place? That would be my question, but I haven't read the case, so I'd be curious to see how it addresses it.
And yeah, I guess that's a good question too, is as an equitable remedy, can we consider that when it comes up through SOA, or would that be something a district court in the first instance has to consider?
Well, I would suggest that detrimental reliance is to its very nature what you're discussing, in the sense that if you're being told, yes, you can have this, and then you take action, you devote time and resources towards doing that, for someone to pull the rug out from you after the fact, even though they were armed with all of the information to know the factors that should have been at play, that is induced conduct by the person who received that information. And in the case of issue, the Supreme Court case, that played out by the city of Dallas and their agency, the board, coming in after the fact and saying, hey, we know we approved you. We know we kept on rubber stamping this all the way along the way. These laws and rules that are on the books and clear as day, the language is written down. Despite that language, we induced action by you by affirming your ability to move forward. That is the detrimental reliance that occurred in that case.
No, I appreciate your argument. I would like to make another observation about the nature of the State Office of Administrative Hearings. It's a reminder, they are not courts of general jurisdiction. They are courts to hear administrative matters. They are not courts of equity, unlike a district court or other courts. So going back to Commissioner Harvey's question, perhaps this would be an argument, is district court or otherwise. I certainly don't think SOA is a place that can adjudicate or consider it. It's just an observation. I do appreciate the argument, though.
Thanks.
I'd like to ask you, Mr. McCullough, you continue to say that TCOLE was aware. Do you have any sort of documentation proof otherwise showing that TCOLE as an agency who approves the paperwork that's submitted saying your paperwork is in order ever knew about this conviction up until they were made aware of it from this larger agency more recently?
Every time that a PHS is submitted, it is notified to the licensee that it is a TCOLE document, and they're responsible for providing full, truthful, and accurate information to the department they're applying to and TCOLE under the TCOLE rules pertaining to PHS. TCOLE has constructive notice through that document, whether they choose to exercise resources towards reviewing every single one of those documents. It's a TCOLE problem. It is not a licensee problem. They have constructive notice, and choosing not to review those documents, I think, is not not a reasonable argument or position for TCOLE.
I appreciate your answer, but that does not answer my question.
If nobody from TCOLE elected to take the time to read the document that was submitted to them, then I suppose the information may not exist with any TCOLE officials had, but it is on a document that is TCOLE property, and the TCOLE would come after a licensee if they fail to fill out that documentation correctly.
But we can rightly assume that once TCOLE was made aware of the issue, action has been taken. Because at this point that agency said, here's this thing we're concerned with, TCOLE then looked at it and said, oh, you have rightfully concerned. So at that point, when we can show that actual notification was made to TCOLE, TCOLE took action. So the argument that we're approving when we're not, we're approving that paperwork was completed versus notification of the actual offense.
So I think that there's not an argument for reasonable ignorance if this documentation has been previously submitted. Someone may have seen it from TCOLE that no longer works here now, that worked there then. We can't speak to those facts because they are not present material for us to be able to look into. But because somebody made a decision in 2023, as opposed to when this information was made available to TCOLE back in approximately 2015, I believe, I think that that is an argument that seeks validation of an incomplete practice on TCOLE's end, as opposed to consistent notification by the licensee.
Thank you.
Okay. I'm going to make some statements and ask a couple of questions here. To clarify for everyone here, it is, and I'm going to ask the executive director to either affirm or deny, but it is, according to all of the TCOLE rules, it is a law enforcement agency's responsibility to conduct a background investigation. TCOLE does not do that.
That is correct, and that is reflected in our rules.
Yeah. So while TCOLE might have information, there was never any intent that TCOLE double check an agency's work. We rely on the agencies to do their job. And in fact, we have some cases here where agencies were cited for not properly doing their job. So the agencies and the chief administrator are held responsible for ensuring that a proper background investigation is done.
That's correct, and I'm confident we can quickly give a statistic on the number of appointments that are made each year, and it's unreasonable to believe that even with the nearly 3 times the size of TCOLE over the last few years, that it would be implausible to think that we could look at every single PHS. That's not a reasonable thing. To the degree that we would be able to find the needle in the haystack, such as what's suggested.
Okay. And then for general counsel, you talked at the beginning, I believe that you cited towards the end of the rule that the licensee has responsibility for not accepting a license if they're not qualified. Is that accurate?
That's correct.
Okay. And I think we're, I guess I have a question for you, sir. You're not negating the fact that domestic violence occurred.
So
That's a yes or no.
that has not been our argument, no, ma'am.
I'm not saying it was your argument. You're not negating that Mr. Santiana.
No, ma'am.
Okay. So I'll finish my sentence. You're not negating the fact that he committed domestic violence.
No, ma'am, and I apologize for interrupting.
Okay. So reading the case, we have domestic violence that occurred. We have a victim that was struck, who was kicked into a closet, and then who was held against her will for overnight, I mean, approximately 10 plus hours. And hence the charge, hence the conviction. And that's really what the rule speaks to. So I think we may have gotten a little into the weeds on it, but at the end of the day, that's really the crux of the rule and why we're here, is because of the actions. And now it's our decision to make moving forward what we do with this information. So are there any additional questions or comments from anyone?
I'll just make one last comment. You know, the ALJ even said in their own statement here that they, wait, wrote it down here. The ALJ said that he was ineligible and subject to cancellation. And I mean, they made that very clear in their proposal for decision that at the root of the issue the presiding officer said is he never was eligible to begin with. And regardless of what came afterwards, and it's hard. You know, I'm all for a person reforming their life and making better choices. I'm a big advocate for it, and I wish those people well. But what we're looking at here is, should they've ever been given a license to begin with? And the answer here, which is agreed to by the ALJ, was no. And that's what this issue is about. The other issues are definitely worth looking into and exploring, because I do have concerns with some of those issues that led us to why we're here and put that person on the pathway of why we're here today. And, you know, but the root issue of why we're here, I think, was addressed by the LJ and concluded to the same conclusion that I've come to, is that he was ineligible to begin with. And those are my closing remarks on that, ma'am.
Do we have a motion?
Yes, I'll make a motion. I move that we accept the recommendation of the LJ to cancel this license, along with a change to the conclusions of law number 7, 10, 12, 13, and 14 as indicated in the response from TCOLE to the ALJ.
I second it.
Just for clarity, I believe it's 12 through 14 is the recommendation.
Yeah.
Right, is that what you said, or did you say 12?
I just 12, 13, and 14.
Oh, okay, sorry, my bad.
Yeah. Okay, we have a motion and a second. All those in favor say aye.
Aye.
Aye. I'm sorry, we're going to do a roll call vote. My apologies.
Commissioner Kim Lamo,
Yes.
Commissioner Justin West,
Yes.
Commissioner Janet Atkins,
Yes.
Commissioner Justin Berry,
Yes.
Commissioner Connor Harvey,
Yes.
Commissioner Sergio Sines, Commissioner David Kreiner, Commissioner Jason Griffin,
Yes.
Commissioner Rita Watkins. Okay, all voted in favor, motion passes.
Thank you. Motion passes. I know that this is not the conclusion that you were looking for. Anytime, I'm going to speak a little bit to Commissioner Berry's earlier comments. Anytime that, you know, we receive one of these cases and situations and study them and have conversations, both with people, you know, that are connected to the case or with TCOLE staff. You know, if there are areas that we can, you know, make improvements to, we will certainly look at that. But unfortunately, here today, it really came down to the rules and what the commissioners believe what the standards for the rules are. So my apologies that it didn't go the way that you wanted. Do very much appreciate you being here today, and we will take the other comments that you had into consideration and see if we do need to make any changes. So any other questions or comments? We are going to take a 15-minute break. You will show us back in session, please. Thank you very much. We are now going to move to Kenneth L. Broyles with Assistant General Counsel Aaron Heath.
Thank you, and good afternoon, Commissioners. My name is Aaron Heath, Assistant General Counsel with TCOLE, and this is a proposal for decision for Respondent Kenneth Broyles. The Executive Director recommends that the Commission reject the Administrative Law Judge's recommendation and revoke the peace officer license of Respondent Broyles. Respondent has 2 Class A misdemeanor criminal dispositions, one for contributing to the delinquency of a minor and one for unlawfully carrying a weapon. Respondent has also been arrested multiple times for assault. In 2 personal history statements provided to ISD police departments, Respondent Broyles denied having ever been fingerprinted, arrested, charged, convicted of a misdemeanor offense, or placed on court probation as an adult. Also, when questioned about the mugshot from his 1996 arrest for assault, Respondent denied that the picture was of him or that he had been arrested. The PFD found it is undeniable that the information he provided was false. The questions contained in the report clearly request information regarding deferred adjudications and arrests, which Mr. Broyles did not disclose. The PFD also concluded that Mr. Broyles' denial that he is not pictured in the mugshot is not credible. The issue in this case is whether an applicant providing a personal history statement for prospective appointment to a law enforcement agency has made, submitted, caused to be submitted, or filed that PHS with TCOLE. And as you heard in the previous case, a PHS is a TCOLE document that an applicant is required to complete and submit to apply for enrollment in a licensing course, licensure by TCOLE, or appointment with a law enforcement agency. It captures information required by law for TCOLE to determine an applicant's eligibility for enrollment, licensure, or appointment, or for an agency to determine an applicant's suitability for appointment. This includes criminal history record information and proof that the applicant meets the minimum standards for enrollment or licensure. Training providers and law enforcement agencies are required to maintain an applicant's PHS on behalf of TCOLE in what is referred to as the TCOLE file. Next, Rule 223.19F provides that the license of a person who has made, submitted, caused to be submitted, or filed a false or untruthful report to TCOLE may be revoked. Unsupported by case law or the plain language of the rule, the PFD attempts to add qualifying phrases and elements to Rule 223.19F. However, the phrase made, submitted, caused to be submitted, or filed is intentionally broad, with cause to be submitted expressly contemplating an indirect submission and broadly interpreted by Texas courts to reach more actors in the submission process. And the fact pattern of this case is a perfect example of a licensee causing false or untruthful information to be submitted to TCOLE. A law enforcement agency, which is regulated by TCOLE as part of an application for appointment, which is a process regulated by TCOLE, submitted a PHS that is a required form created by TCOLE to TCOLE so that TCOLE could determine whether the licensee is eligible for a TCOLE license, which is a core function of TCOLE. Thus, as a matter of law, an applicant providing a PHS for appointment purposes has made, submitted, caused to be submitted, or filed that PHS with TCOLE. And under Rule 223.19, the Commission has the authority to revoke a license if a licensee submits a PHS that contains false or untruthful statements for prospective appointment. This is supported by the recent John Joslin case, where both the Commission and SOA found a violation of Rule 223.19F when a PHS submitted for prospective appointment contained false statements. Respondent has 2 Class A misdemeanor dispositions, including one for contributing to the delinquency of a minor, and has been arrested at least 3 other times. Respondent has not been upfront in disclosing his criminal history to prospective ISD police departments, only providing information regarding the criminal dispositions after being questioned about them. Respondent also testified that he was aware his criminal history was on his record after applying to Cleveland ISD in 2018, which means that at a minimum, he had knowledge when he applied to Huffman ISD in 2023 that his record contained criminal dispositions and arrests. And respondent still denies the arrest even after being confronted with a mugshot and matching fingerprints for the 1996 arrest for assault causing bodily injury, family violence in Harris County, Texas. Respondent's repeated and continued false statements in his PHSs, including for an offense involving minors that directly relates to an appointment at an ISD police department, and his continued not credible denial of his 1996 arrest in the face of overwhelming evidence justify revocation because respondent lacked and continues to lack candor. For these reasons, the executive director recommends that the commission change findings of fact numbers 10 and 12 through 14 and conclusion of laws number 7 and 16 through 17 of the PFD as demonstrated in the proposed order of revocation and revoke respondent's peace officer license. I'm available for any questions.
I've got a question if I may. Oh,
Let's wait till,
I'm sorry.
yeah. So yes, ma'am, if you could step up and state your name, please, and your relationship to the case.
Good afternoon, commissioners. My name is Tara Zitzen. I'm an attorney with CLEAT, and I am here representing today Mr. Kenneth Broyles. It is my pleasure to represent him in this matter. We're here today to ask you to adopt the administrative law judge's proposal for decision, who was in the best position to make the decision since she heard the testimony and reviewed all of the evidence in the case. We are also asking you to reject TCOLE's proposed order of revocation, and to that effect, we have submitted a brief and a proposed order of our own, which you should be in receipt of. Mr. Broyles was licensed as a peace officer in July of 19. Impeccable record of service by his community, and the record will show that he is a man of good character who intends to spend the rest of service to law enforcement. He's in his mid-50s, and he has indicated to me more than once that he loves to do it, and that's all he wants to continue to do. We're not here today claiming that he made certain on the PHS that are in question. What we are saying is that he did comply with the spirit of Texas Administrative Code Section 22319, which has to do, of course, with reporting criminal offenses, because even though his arrest for the contributing to the indecency of a minor sounds bad, but what actually happened was that he was a minor himself at the time. He had beer in his truck, and the other kid in the truck, who is also a minor, said it's his beer. It wasn't anything sexual in nature, nothing involving a child, nothing involving anything like that. It was a kid that had beer in his truck. With regard to the unlawful carry of a weapon, he was pulled over and was discovered to have a firearm in his vehicle. Those were both Class A misdemeanors, and in fact, those arrests were eligible for orders of non-disclosure because the cases were dismissed after he successfully completed deferred probation, and I want to say that dates back to 1991. Unfortunately, Mr. Broyles at the time was never informed that when the cases occurred, and he also testified in the SOA hearing, that when the cases were dismissed, he honestly believed that they were cleared off his record automatically, which fortunately is a misconception that a lot of people have, and he just didn't know that he had to do something affirmative by filing a petition for non-disclosure. Despite that fact, he provided documentation of the deferred adjudications, and it's our position that there may have been a technical violation, but really this is a public policy argument and it is an equity argument. The spirit of the law is calling for honesty, and he did that. He gave the documentation to every agency he applied to. They knew about it, and the spirit of the law can't be that we take away a peace officer license for inadvertent omissions and misunderstandings by an officer. Regarding that arrest there, Mr. Broyles testified in the SOA hearing that he had no memory of that arrest. He doesn't believe that that was him. There was testimony elicited that in the mugshot on the far left, there is a scar above one of the eyebrows. I can't remember if it's the left or right eyebrow. And in the SOA hearing, no one was able to observe that same scar. It is vaguely similar, I suppose, but it's his position that that wasn't him. Mr. Broyles is not an application. You can't look at this case in a vacuum of certain omissions that were technically made, but realistically, the information was there. He never tried to hide anything. He never tried to mislead anyone. He would be an asset to any agency, and in fact, he has job offers pending your decision here today. His future shouldn't be determined by minor mistakes that he made that were technical in nature. He's done nothing to undermine the public trust, and rather his career has served, in fact, to strengthen it by virtue of his exemplary service. Two sections of the Texas Administrative Code, 223.19, are relevant. Section B states that the license of a person convicted or placed on community supervision for an offense directly related to the duties and responsibilities of any related office held by that person may be revoked. There are 4 factors that I don't have time to get into right now, but I did provide a case that cites those factors, and the main one is the nature and seriousness of the crime. It's not serious to give another minor a beer when you're a minor, and it was so long ago. It was in the early 90s. I think that it's safe to say that anyone may have made a similar mistake back then, and he certainly learned from it. The 2 deferred adjudications are not serious. They do not relate to the purpose for which his license is required, and we are asking that you do not revoke his license today. Thank you.
As I mentioned before, respondent became aware of these offenses and arrests were on his record after applying at Cleveland ISD, before applying at Huffman ISD. He also testified that for every agency he worked for, he has submitted the criminal documents. Why did he have to keep submitting these documents to these agencies? And the PHS doesn't ask if the arrests or offenses are on your record. It asks, have you ever been arrested, fingerprinted, placed on probation, everything we discussed previously. This is something he should be familiar with, as criminal law and procedure are part of the BPOC, and peace officers are exposed to criminal history record information as a part of their job. Next, he did not disclose them on the PHSs. He only provided them after being questioned about them by the agencies. Again, he was not upfront in providing this information, and the rule does not require intentional or knowing. If someone doesn't remember being arrested for an offense and is presented with a mugshot that is undeniably a picture of themselves, they don't deny the mugshot is of them. They acknowledge it, but say, I don't remember being arrested. His testimony is, question, okay, do you see an individual in that, depicted in that photograph? Answer, yes. Question, do you know who that individual is? Answer, no, ma'am. And following up, question, and I would like to point out the date on this. It's from November 29th, 1996, but you're saying that this is not you, is that correct? Answer, yes, ma'am. This demonstrates a lack of candor and accountability. And also to the argument, we're not revoking based off of a disposition for a directly related offense. However, contributing to the delinquency of a minor directly relates to the duties of a peace officer who is supposed to uphold and enforce the law. And it also is directly relevant to appointment at an ISD because the offense involves encouraging or causing a minor to commit illegal behavior. And for these reasons, and then one final thing. The documents that he kept providing noticeably lack any order of non-disclosure or expunction. And as I said previously, you should be aware of criminal law and procedure, realizing that without this order of non-disclosure or expunction, the case is still on his record. Thank you, and we still urge revocation.
Okay, do we have any questions, comments from the commissioners?
I've got a question now. Just so I'm make sure I'm understanding. This is just about revocation and not cancellation, because I think the PFD said cancellation can happen.
Correct. Oh, sorry.
Yeah, for both of you. Yeah, yeah.
No, that's correct. We're no longer pursuing the cancellation route.
Okay. And then, for the gentle lady, when you say spirit of the law, what do you mean exactly? What do you reference here?
When I say that, I suppose what I'm really indicating is that I think that there can be technical violations of the law, and not putting these things on the PHS is technically a violation. But when I say spirit of the law, the lack of public trust that TCOLE is arguing is in effect here, that's not really true, because he could have just not given anyone those documents, but he did it knowing that it was still on his record because he just didn't understand that he had to do something to get it off his record. So I don't think that what he did in terms of omissions rises to the level of something that would warrant revocation, because again, and if I may, just going back to the I'm going outside of the scope of your question. I'm sorry. Yes, my answer is it's more of an equitable argument. I guess I'm just asking you to consider the fact that even though he may not have checked the boxes that he should have checked, he still gave the information. He didn't try to hide it.
Thank you.
I have one question. The minor that's being referenced here, what was the actual age of that minor? Because
Mr. Broyles is here. If you, may I think it was about 15 or 16, but I would need to clarify
well,
that.
I mean, on our side, do we know, on the TCOLE side, do y'all know the age of that minor? Was that revealed in any police reports, or I don't recall seeing that?
I don't recall the age of the minor at this time, but the criminal documents were admitted into evidence and were part of the PHS before you.
I just didn't see it. Okay. I was just curious if it was like an 8-year-old, or are we talking about like an 18-year-old, a 19-year-old?
And when I said PHS, I meant the proposed.
I know what you, yeah.
Yeah.
Okay. All right.
Would I be permitted to make, I'm sorry, this is my first time appearing before you. Would I be permitted to make a proposition for discipline?
Sure.
Yeah.
So I think that it would really be such a shame at this juncture in his life and in his career to take his license away from him. And so in lieu of revoking his license, I had the idea that maybe, and I don't know if this is possible, the 3 years that he's sort of been going through this and been in limbo, maybe that could serve as a retroactive suspension of sorts, because he has learned his lesson, never meant to hurt anybody. And I don't know if that's even something that's possible, but I'm just trying to be creative here, because what we are not trying to do is not acknowledge the issues. We are, and we are owning them. But I just thought that maybe that might be a possibility in lieu of the harsher sanction of revocation. Thank you for letting me speak on that.
Any other questions or comments? Okay. Do we have a motion?
So that I say this correctly, I make a motion to accept the proposal for the decision from the executive director. Am I quoting that right? The revocation?
Commissioner Atkins, I want to make certain your intent here is to accept the proposed order from the executive director seeking to revoke respondent's license.
Yes.
Would that also include the recommended changes to the conclusions of law as stated by TCOLE staff?
Yes, yes,
And the findings of fact.
And the findings of fact.
yes.
Okay, we have a motion. Do we have a second?
Second.
Okay, we have a motion and we have a second.
Commissioner Kim Lamo,
Yes.
Commissioner Justin West,
Yes.
Commissioner Janet Atkins,
Yes.
Commissioner Justin Berry,
Yes.
Commissioner Connor Harvey,
Yes.
Commissioner Sergio Sines,
Yes.
Commissioner David Kreiner,
Yes.
Commissioner Jason Griffin,
Yes.
Commissioner Rita Watkins. All voted in favor, motion passes.
Okay. Yeah, I just wanted. Oh, there she is. Thank you again for being here and for the time that you've put in for it. No, it's okay. No, thank you very, very much. We appreciate you and the time that you've put into this. Also, you know, the effort that you put into traveling here. We very much appreciate it. And I know this isn't how you wanted it to end, or not the decision that you were seeking. But anyway, we do appreciate you. Okay.
Madam Chair and Commissioners, before Dan and Robert have an opportunity to speak to you about, present their side of this case and how their argument as to the facts applied to the law, I would like the opportunity as General Counsel review with you one of the main core statute it question at issue, and that's 1701-312, and take a few minutes to discuss that. Again, just walking through it, refreshing your memory as to, number one, its existence, some context and history, and then leave it to Robert and Dan to argue their positions on behalf of the Executive Director and Mr. Fredley, respectively. So. Fantastic. Commissioners, the main, and with one small exception for a conviction of barratry, the only statutory, again, with one small exception.
John, I might, for the online listeners.
Yeah, thank you. Thank you, Dan. Commissioners, with the small exception for a conviction of barratry under 1701, the only statutory bar to licensure as a Texas peace officer, jailer, or telecommunicator, and the floor, the absolute floor for licensure, is for a person who has been convicted of a felony is disqualified to be an officer, public security officer, telecommunicator, and they may not be appointed as such. Subsection A of 1701-312 has existed as long as the Texas Commission on Law Enforcement, since the mid to late 60s. Subsection B, for the purposes of this section, a person is convicted. Subsection B has been added in 1983. A person is convicted of a felony if a court enters an adjudication of guilt against the person on a felony offense under the laws of this state or another state of the United States, regardless of whether the sentence is probated and they're discharged. But as you'll hear argument today on this, the accusation, complaint, information, or indictment is dismissed, and that person is released from all penalties and disabilities resulting from the offense. There's a provision in the Texas Code of Criminal Procedure under Article 42. It's been renumbered. I know Dan will correct it later, or one of the parties will. This is the shorthand term for this is called judicial clemency. Now we go down to subsection B3. The person is pardoned for the offense unless the pardon is granted expressly for subsequent proof of innocence. So in other words, if you go and get a plain vanilla presidential or gubernatorial pardon, a brother-in-law pardon, that's not good enough. It has to be proved for actual innocence for it to remove the bar, the permanent bar of being convicted of a felony. Judicial clemency is not enough. A nor is a pardon unless it's for proof of innocence enough to remove a conviction, a felony conviction as a permanent bar. Are there any questions about this particular provision before we turn it over to the attorneys? Okay. Thank you.
Okay, we're going to hear the case of Nathan L. Fredley. And we'll hear first from Assistant General Counsel Daniel Walker.
Ladies and gentlemen of the commission, I want you to, for a moment, imagine a situation anywhere here in Texas. It could be right up the road here from where we stand today in Bernie. You have a Bernie fire cadet. Young man is there, and he makes a choice. He uses the company gas card that's been issued for the vehicles on his personal vehicle. He ends up getting charged, and he ends up pleading guilty to credit card abuse, a felony in the state of Texas. After he has completed his probation, he exercises the relief under 42A.701, judicial clemency in the Code of Criminal Procedure, exercises those rights to see the plea set aside, to see his rights restored, to see the information dismissed, the indictment dismissed. After he does all that, he goes and he gets a license. He gets a license with TCOLE as a peace officer, and he's working for the Bernie Police Department. Now, what would be the result of that scenario? Under that scenario, upon finding out that there was this existing conviction, a judgment of guilt that existed for a felony, he would be canceled. We've been talking about cancellation a lot today. He would be canceled and he would be permanently disqualified as a convicted felon under Occupation Code 1701-312. I'm going to now take you out of the realm of hypothetical and talk about the facts of this case, and I'm going to show you a timeline. And this timeline is going to help walk through what happened with Mr. Fredley's case in Arizona. This takes us all the way back to the year 2000. As it gets blown up on the screen, you'll see it. This takes us back to the year 2000, when Mr. Fredley was, in fact, a fire cadet with the Show Low Fire Department in Show Low, Arizona. He used the gas card for personal vehicles, and he was charged in the court there. He pled guilty to the charge. It was an amended charge from the original charge, but it's specified in his documents and even in his own hand, fraudulent use of a credit card, a Class 6 open-ended felony. That is the same thing as a credit card abuse in the state of Texas. That is the unauthorized use of a credit card by an individual to try to get something with the intent to obtain a benefit. So he uses that and he pleads to that. You see all through the documents with his terms and conditions of probation. You see the sentence of probation. He serves that probation and closes that out in 2002. You see the blue box there where he finishes and there's a closing case summary. And then after the completion of the probation, we see Mr. Fredley come back and start exercising different rights to restore, different mechanisms to restore some rights and to remove some of the disabilities of his conviction. We see the civil rights restored, restoration that began in 2004. And in 2004, he's notified this is not going to, you're not going to get the full effect of the relief you want until you've completed your probation. You have to complete that in full. And why that's important is when we come back in 2006, we see this application for the restoration of rights, the withdrawal of the plea, the vacation of the conviction. We see in Arizona law under 13905 that it is clear that what Mr. Fredley availed himself of for his fraudulent use of a credit card conviction in Arizona is the equivalent of judicial clemency under 42A.701. That's what he got, that's what he went through, that's what he received. We saw Mr. Fredley came back in 2013 and he exercised additional rights, got his gun rights restored. And after all that restoration of rights, that was all judicial clemency and the conviction still remained as a conviction. The only thing that removes that conviction from being a conviction is, as we saw in 1701-312, is an exoneration. It's a pardon for actual innocence or some form of exoneration that says, that removes the stain completely, and that is contemplated in statute. Judicial clemency specifically does not and continue to be with you for licensing purposes. The relief wasn't enough, quite simply. So we see that he's licensed in 2016, and then we get the rat back hit. was investigated by TCOLE, and you see the facts as you look at all the exhibits in the PFD packet. You see that all the facts about how it was looked into, what happened with the background check, how this ended up happening. At the end of the day, even with this redesignation in 2025, again, that wasn't enough. Mr. Fredley is convicted of a felony, and the relief has not been enough to change that. The judicial clemency was not enough. The redesignation as a misdemeanor does not matter because a fraudulent use of a credit card is a felony. It's a credit card abuse and a felony in the state of Texas. He is permanently disqualified. If this happened to the Bernie fire cadet, he would be permanently disqualified. If a current licensee like TJ went to Arizona right now and did this, he would be permanently disqualified and would lose his license because he would be a convicted felon. In light of all that, the ALJ is incorrect. The relief is lacking. The conviction is a conviction.
We're done.
Sorry.
Gentlemen, if you will please state your name and your relationship to the case, that would be most appreciated.
Thank you, members of the commission. My name is Robert Rogers. I'm the attorney for Trooper Fredley. I'll be, excuse me, Nathan Fredley. And commissioners, I appreciate your time. This isn't the hypothetical Bernie cadet. This is a real human being that's before you that has never been convicted of credit card abuse. What's an important distinction and what's important is that I would ask the commissioners to focus on the judgment that occurred back in 2000. Not disputing that young Nathan Fredley made a terrible mistake in 2000 when he used a credit card without his boss's authorization. Since that time, he has availed himself of every possible relief that he can get, including what's called the vacation, the order of vacation. And it's in the packet. An Arizona judge did not set aside, did not withdraw or set aside or dismiss. The Arizona judge entered an order vacating the conviction and withdrawing the guilty plea. I don't want to get bogged down on that. I'm preserving that in case I need to file an appeal in district court. What my focus on is the actual conviction. If you look at the language, staff attorneys in their proposal for decision cite that Fredley was convicted of a class 6 open-ended felony for violation of Arizona Revised Statute 13-2105, which closest equivalent is credit card abuse in Texas. That's not true. Nowhere in the judgment paperwork, in the charging paperwork, nor in the judgment paperwork is 13-2105 stated. In fact, it specifically says that it is the judgment of the court that the defendant is guilty of the crime of fraudulent use of a credit card, a non-dangerous and non-repetitive offense in violation of ARS 13-2310. So whether they call it fraudulent use of a credit card or not, the statute is what controls. Earlier today, we had a gentleman whose conduct was a Class B conduct, but he pled to a Class A statute and he was held accountable for the statute that he pled to. We're asking you to do the same thing here and hold Trooper Fredley accountable for the statute that he pled to, which Arizona Revised Statute 13-2310 is theft by deception. And the ALJ set that out in clear detail in the ALJ's proposal for decision. And so the closely equivalent offense that he should be held accountable for, based on the facts, based on the only evidence you have before you, is 13-2310, which is theft, which is a Class B misdemeanor, which has been vacated, which he has availed himself of all relief. Since that time, he served in the Army Infantry. He's gone overseas. In 2015, he applied to DPS. He was transparent about this. We had a DPS sergeant that looked into it, called Arizona to make sure they were clear on what the law was. We had a DPS lieutenant, a major and captain review it and decide, yeah, he's qualified. And for the last 9 years or close to 10 years, he's put his life on the line on the roads and highways of the state of Texas. And he's done an exemplary job, as the record shows. All we're asking is that you follow the law, you follow the ALJ's proposal for decision. The statute, the facts show he was only adjudicated at one time for a misdemeanor. I'll let Trooper Fredley.
I have just a few seconds. I just want to address both legal teams are arguing the understanding and interpretation of the law that is trying to be held against me due to the paperwork that I provided from day one. I simply want to highlight that my case has been before an administrative judge whose sole purpose is to interpret the law. And twice that judge ruled in my favor, saying that I met the minimum requirements to hold a Texas peace officer license and that my license should not be canceled. I also want to recognize each of you and for your willingness, dedication, and love of the state and your ability to serve it.
Thank you.
Commissioners, the ALJ misinterpreted the law in this case, and the ALJ misinterpreted the documents. As you look at those documents, I'm going to take you to the actual plea bargain agreement on page 3 of TCOLE exhibit number 3. And I'm going to point out, this was the agreed plea bargain agreement. There was a 2310 involved. Mr. Fredley was indicted for fraudulent schemes or artifices under 2310. That is a class 2 felony. A 2310 is not a class 6. A 2310 is not a fraudulent use of a credit card. And if he was going to be charged with what he was indicted with, there would be no amendment. But there was an amendment. The parties agreed, and we see it clearly on this page. I'm going to point out all the pages to you. There was an amended count 1 to change it to a fraudulent use of a credit card, a class 6 open-ended felony. The attached statutory numbers that are there, some are referring to punishment ranges. They did not update the 2310 to say 2315, and that's not what I'm telling you here today. What I'm telling you here today is there are 3 items that we have to make sense of. There's a charge of a fraudulent use of a credit card, there's a class 6 felony, and there has been an amendment. It is clear that the intent of that court was not to convict him of a fraudulent schemes or artifices, a higher level offense, a class 2 felony, as opposed to a class 6. This amendment is clear on page 3. I'm going to go through these quickly for the sake of time. Page 7 in the pre-sentence report, it's clear, it says there was an amendment. On page 12 of TCOLE Exhibit 3, on the terms and conditions, it's an amended count 1. And 8 different times throughout TCOLE Exhibit 3 and respondents' exhibits, it says, even in respondents' own hand, that this was a fraudulent use of a credit card, a class 6 open-ended felony. How else do we know that it's an open-ended felony? An open-ended felony can be redesignated from a felony to a misdemeanor under Arizona law. That's something that's limited to a class 6. And in 2025, that's the exact relief that Mr. Fredley came back and got, to have it redesignated from a felony to a misdemeanor. He could not have done that if it was a 2310. He could not have done that if that was a fraudulent schemes or artifices. It was a fraudulent use of a credit card. It was a class 6 felony, and amendment was intended, as is evident throughout the documents. So when I say the ALJ misinterprets the law and TCOLE exhibits, it is clear what the intent was, it is clear what the effect was, and I will take you to TCOLE exhibit page 24 in the upper right-hand corner there. And I'll scroll up and show, here we are in the respondent's own hand, where he said that the conviction was for a fraudulent use of a credit card, a class 6 open-ended felony. Even he, when applying for this relief, knew exactly what it was. And in Texas, as SOA has found in past cases, this is a credit card abuse. Thank you.
Commissioners, questions?
I want to hear more about the definition of conviction and the vacation argument, assuming we agree that the crime is 2310 and an equivalent one in Texas that would qualify. What effect the vacation and withdrawal of the guilty plea has, if anything?
I'm sorry, Keith.
Sure. You said you were going to save the vacation argument for later, but I'm curious to hear about it now, assuming we agree with the commission that the crimes are equivalent in Texas and it was 2310. What effect, if any, the vacation of the conviction and the withdrawal of the guilty plea has?
Yeah, and just to clarify, 2310 is the equivalent of a misdemeanor in Texas.
Yes, I'm sorry, 2105 is
And so the judges, so the language in 1701 that Mr. Beecham went over talks about all these different things, the judicial clemency language. What's different about the language in the order of the Arizona court is the word vacated. Vacated has a different connotation than setting aside or just putting over here. Vacated, even, you know, in a Supreme Court in Hewitt, I don't have the exact site. It's in the it's in both. It's in the ALJ's proposal for decision, and the TCOLE staff distinguishes it, but it causes the conviction to be wholly nullified and the slate wiped clean. And so I feel it's an additional step that is not contemplated by the Texas judicial clemency statute. And that's my, I don't have anything that compares Arizona's vacation to Texas judicial clemency, but that's my argument.
Yeah, that's I think you hit it. That's where I'm hung up a little bit, is there seems to be a disconnect between Arizona law and Texas law, sensibly because they're different states. And is the starting point when we think about this, what vacation means, and if it means kind of a plain, as the Arizona courts say, or like a plain text definition, nothing from the beginning? Or is the starting point, what does conviction mean under Texas law under 1701-312, and then figuring out whether a vacation has any effect on that? And that's kind of a where do we start to interpret the statutes and orders point. I'm curious to hear both of y'all's thoughts on what's the proper place to begin our analysis.
I mean, my position is the vacation takes us back to pre-conviction, that it doesn't occur. And so that's, I guess, simplified my position.
Right. But if we accept that the definition of conviction in Texas, which it's not really a definition, but it says for purposes, it means if a court enters an adjudication of guilt, right, and it says regardless of these other things, whether the vacation matters, and that would be us starting with the term conviction under Texas law, or whether we start with the term vacation and then go and look at Texas law next and say, well, there's nothing there because it's nothing there from the beginning, or whether we start by interpreting Texas law of conviction and then going and looking and saying, oh, the vacation doesn't matter. And maybe I'm not articulating that clearly.
Well, I guess my opinion is that the vacation that occurred in 2006, I believe, but the vacation occurred, nulled the conviction, so there is no conviction under Texas law. And so that's one argument. And then my other argument is that the conviction is laid out in the judgment for the 2310 misdemeanor.
And Commissioner Harvey, if I understand your question, I'm trying to process it and understand it in order to kind of think through 1701-312 here. Are you thinking of, as it is under has been convicted, what the meaning of? I think counsel, they talked about the Hewitt case, which is cited in the proposal for decision, and that's the language we have at issue here and how that's been interpreted by Texas courts.
Yeah, so the idea is, okay, we have 1701-312. A says a person who's been convicted of felonies disqualified to be an officer. Okay, what does convicted mean? You go to subsection B, conviction means a court enters an adjudication of guilt, regardless of these three Romanettes, or not Romanettes, subsection Arabic numerals. And as we commission, when we look to enforce this, is that where we start? Or do we start by looking at the Arizona vacation, and then it's like, well, then we never get to the Texas statute because there's nothing there, or start with the Texas statute, figure out what a conviction is, and then figure out whether vacation qualifies as an exception or not?
I think it's, and I will give my perspective from speaking and interpreting this for years, is number one, you have to start with the Texas statute, because as Cuellar and other cases which have interpreted judicial clemency in other contexts, in fact, of vacated convictions being used for unlawfully possessing firearms cases, is allowing the vagaries of other states' law for a potentially a district court judge to issue an order in another state, which would equate to you're giving it the equivalency of a pardon in Texas. You're giving it the weight of something which it does not have in Texas, and allowing an out-of-state, again, dependent on the vagaries of whatever state law it is. So I think a sober starting point is what is the plain language of 1701(3)(12). What has been convicted, because certainly the proposal for decision gives great weight to what it claims is a retroactive component of the word has been convicted versus has been convicted as it's been interpreted by the Court of Criminal Appeals and other United States Supreme Court cases.
I think that makes sense to me.
And I can give you, I'm sorry to interrupt, I can give you an example on how this works, particularly in the context of a vacated conviction.
I'm okay.
Okay.
And for subsection B2, I know what a complaint, information, indictment are. What's the understanding of accusation? Is that just an allegation, or is there some technical meaning on this?
I think that's, and I will say that that's kind of a remnant that has been in that provision. And I don't know if that goes back, try to encompassing all not just specifically indictment, et cetera, but capturing all those pre-trial type documents, charging instruments, trying to give it as wide a net as possible to capture all of those things in order to restore a person's civil rights who gets as grant of judicial clemency. It's meant to be broad, is what I'm getting at.
So this is kind of esoteric in a way, I guess. But if the judgment is vacated, you can still look up a case number and find the charging instruments and find everything in the proceeding in this case, right?
Correct.
So the accusation or complaint or information would still be there and still pending. It's not like those have been dismissed.
Could be. Well, if you look at that timeline, there's been orders in applications. If it was vacated, I guess one question that I would have, if it was vacated in 2006, how is there any jurisdiction to reduce it to a misdemeanor in 2025?
That's a good point.
And vacated convictions are used for other purposes all the time, contrary to what the proposal for decision says. And I'm only bringing this up because, again, it's the interpretation of 1701(3)(12).
Okay. Thank you.
Commissioner Harvey, could I briefly answer a question that you had, or speak to one element of it briefly?
Welcome to all the thoughts there are.
I just wanted to clarify something you said, and the council said back, is that a 2310 fraudulent schemes or artifices, that is not a given misdemeanor in the state of Texas. It's fraudulent schemes or artifices. It has a definition. It's not a theft case. Arizona has a theft code, and what the PFD did was equate it to a theft here in the state of Texas to try to make it the same thing. Fraudulent schemes or artifices is a higher level offense. That's different. We have a fraud code in Texas that delineates various means of fraud, including one of those being fraudulent use of a credit card. So it's not a given that a 2310 equates straight to a misdemeanor. We have a misdemeanor equivalent. It is something the ALJ applied that I would disagree with.
I got a quick question, and maybe our executive director may be the person that might know the answer to it. Your counterpart in Arizona, I don't know if you're familiar with their systems. In 2016, would the respondent been, eligible for licensure at Arizona with the case before us today?
I don't know.
You don't know?
I don't know. I'm not sure what they're, I'm pretty certain that they would not allow a convicted felon to get a peace officer license. That's pretty universal across the U.S. But if all of this matters for Arizona, and they look at a vacated felony, they may have that as something that they would allow licensure for. But I don't know that for sure.
I was asking because we're being asked to look at this state's practice of law and license and our way of licensure and how we're looking at our laws. So I was curious because, you know, ours is very clear. If you have a felony, and at the time of 2016, when he was appointed, it wasn't redesignated to a misdemeanor until after his appointment. So at the time of licensure, which is what we're being asked to really look at, is was he eligible for licensure in 2016 prior to the redesignation of his class? And I'm curious to know if Arizona's equivalent to a TCOLE would have allowed him to even be eligible for licensure. And I don't know if any of our attorneys have insight, or if y'all have insight into that as well.
To that directly, I don't know, but we do work often with people coming into the state who are already licensed or who are moving here wanting to become licensed. I think Texas has some of the highest standards, compared to other states across the nation. In making the determination and working with our legal counsel on whether to accept the PFD or to file exceptions, it seems apparent to me that as from what the ALJ laid out, it would favor an out-of-state candidate over a Texas resident. In other words, if all of this occurs in Arizona, this person, according to the ALJ, would be eligible to get licensed in Texas, but if a Texas resident, all of this occurred, would not be. And the best analogy I come up with is if, I don't know what Arkansas's laws are, but if you have two people that grow up in Texarkana, one that grows up on the east side of State Line Road, does all of these things, they could be a Texas peace officer, but a kid that grows up on the west side of State Line Road and does all these same things, gets all of this relief, would not be eligible to be a Texas peace officer. For me, that can't be the intent of the statute and can't be the intent of our rules. Doesn't make any sense. So in talking with our general counsel, that's why it seemed obvious to file the exceptions and try to reverse the ALJ's ruling.
And I think you wanted to respond as well.
If I may, the 2025 redesignation had occurred because of the case that was brought to my attention, and it was an effort on Arizona's part to help classify and provide some interpretation from their laws to ours. And in that process, I also asked the question about how it would apply if I was there. And they really couldn't understand why I was kind of held to this standard. And again, I understand I'm just, voice on the wall, but in my understanding of what they told me, this would not be an issue in the state of Arizona. It's just a different interpretation. But the 2025 redesignation was an effort on their part to help clarify this whole issue to help understand how that would apply here in Texas.
Yeah, thank you for that.
Commissioner, can I speak one more thing
Please.
to that point? One thing does make it hard for a direct comparison. There's nothing in the record about Arizona's standards, how their post operates. I've spoken to them about it, but one of the things that makes it hard is we in Texas don't have what they call a wobbler provision, a statute where it could be a felony, it could be a misdemeanor, could be redesignated, something that changes like that. We don't have that in Texas. So we have what an offense is. It is this, it's state jail felony. So their analysis is a little different because what it started as, what it end as, they have other rules and standards that play into that. So it's not a direct one-to-one. I don't think I can say definitively he would not be allowed or he would be allowed. I think it would be case dependent because of the wobbler.
Thank you for that clarification.
Got two more questions. So is it the commission's position that the redesignation in 2025 doesn't matter at all then?
Yes, sir. Because what matters is under That's a yes. Do you want more than that or do you want me to
No,
stop?
that's fine. And then, because I'm not a criminal defense attorney, could you have a accusation, complaint, information, or indictment dismissed that ultimately resulted in a conviction without also vacating the conviction? Because it's hard to imagine that if if dismissing one of those would vacate the conviction, which resulted from the charging instrument ultimately, that the statute specifying something greater to be dismissed would mean that like a vacation alone isn't enough. If I think that's.
Could you repeat that one more time? Make sure I'm fully clear in your
Sure.
question. I'm sorry.
So imagine there's an indictment which leads to a felony conviction for burglary or something. And the indictment is dismissed ultimately later on, 10 years later. Does that mean the judgment also is necessarily vacated in that instance? Because
Are you talking about it matters how it's dismissed?
well, because if there's no indictment anymore, because the indictment's dismissed, it seems like a judgment on that couldn't stand, right? Because there would be no.
And I think if we're talking about, if we're getting a grant of judicial clemency, like in this case, or otherwise you wouldn't be able to, let's say you get a conviction.
Right.
You get a grant. We'll speak of judicial clemency because we're talking about 312
Sure.
here. You get everything that's under a grant of judicial clemency.
Right.
You get your right to vote back. You get the right to sit on a jury back. You get perhaps your gun rights back. You certainly do in Arizona. What you don't get, that doesn't make that conviction go away. And if you, for instance, and again, going back to the language used in the statute, has been convicted, you get convicted, let's say you get a grant of judicial clemency.
Well, the statute says is convicted, right? And so that's.
A is has been convicted.
A is has been convicted, okay.
Yes, sir. And when you've been convicted here, you get a grant of judicial clemency. And then, for instance, let's say using the same language, has been convicted, as we have under Texas Penal Code 4604, as the Court of Criminal Appeals has said, if you get conviction, judicial clemency, you get caught in possession of a gun illegally, you aren't convicted for the purposes of that statute.
Yeah.
Does that make sense?
Yes.
But if you go conviction, you get caught with a handgun, and then you get a grant of judicial clemency after the fact, you look to your status at the time you were caught with a handgun, has been convicted. A subsequent vacation or suit of judicial clemency, in fact, you can make the claim in United States Supreme Court, it says you could not have an attorney at that original conviction, and you get it vacated after you were in possession of a handgun, you were still a convicted felon at the time you were in possession of a handgun.
And I think that's what I'm getting at, thinking out loud as we have to do, is if the statute says, hey, a conviction counts regardless of whether the indictment is dismissed, then that means with no indictment, I assume there's no conviction anymore, which says like, hey, even if this greater thing beyond vacating a conviction, but all the way back to the indictment doesn't qualify, it seems like the lesser thing, just the conviction with an indictment or information or whatever still pending,
that's what I
wouldn't qualify either.
That's right. That's right. But it also depends what purposes in statute it may be limited to as well. Obviously, law enforcement licensing purposes.
Sure.
Again, you can get your right to vote back with this. You can get your CHL with it because it's excluded from the definition of conviction, judicial clemency is, and you can sit on a jury, but you still can't get a peace officer license.
Sure. Okay.
Madam Presiding Officer, y'all were given the amended findings of fact conclusion.
Yes, we were.
Okay.
Thank you. Okay. Any other comments or questions? Okay. Do we have a motion?
Make a motion to accept the executive director's recommendation for cancellation of the respondent's peace officer license, as well as changing findings of fact number 1 through 3, 7 through 18, and conclusions of law numbers 3, 8 through 10, or 8 and 10, excuse me, through 28.
Commissioner West, can I
Yes.
speak briefly. So what's before you and what is, we are presenting to be voted on, there's an amended findings of fact conclusion law list. It is substantially the same, but there was some renumbering and maneuvering around. So what is on the notebook in the packet that you're reading, that number has been updated to the paper packet. So it would be as reflected, as simple as reflected in the amended findings is what we are recommending to be voted on.
Okay, so let me restate my motion. I make a motion, we accept the recommendation of the executive director and make changes to the findings of facts and conclusions of law as stated in the amended packet provided today. Is that acceptable, John? Is that acceptable?
Yes. The one dated April 14th, 2026, Commissioner West.
Yes.
Page 19 through 30.
Yes.
Yes. Signed by Daniel Walker.
Second.
We have a motion and a second.
Commissioner Kim Lamo,
Yes.
Commissioner Justin West,
Yes.
Commissioner Janet Atkins,
Yes.
Commissioner Justin Berry,
Yes.
Commissioner Connor Harvey,
Yes.
Commissioner Sergio Sines.
Yes.
Commissioner David Kreiner,
Yes.
Commissioner Jason Griffin.
I'm going to abstain.
Abstain. Okay. And Commissioner Rita Watkins. Okay, we had one abstain. The rest all voted in favor. Motion passes.
Okay. As Melissa said, the motion passes. Gentlemen, I very much appreciate you being here. I know it's not the outcome that you are seeking. At the end of the day, we are charged with, upholding the TCOLE rules, and the votes are always reflective of us doing that. So I wish you the best of luck. And were you here when I was talking to the first gentleman that was here? Okay. So I would offer you the, kind of the same advice. But anyway, appreciate you being here. Thank you so much. Okay, we will move on to the case involving John L. Roselle III, and Assistant General Counsel Daniel Walker will be presenting that.
Commissioners, the final PFD that we have for you here today is one where we come bringing a recommendation that we believe that the ALJ got it right. The respondent, John Roselle, is a peace officer with the Dallas Police Department, John Roselle III. He was convicted or placed on community supervision for disorderly conduct as a Class C misdemeanor involving family violence. The ALJ at SOA agreed with this premise, finding that there was a dating relationship, there was a charge of family violence, there was a plea to a charge of disorderly conduct that involved family violence. ALJ goes on to discuss that extrinsic evidence and testimony showed that this was a family violence offense, and because the standards for revocation in our rules show that if respondent is convicted or placed in community supervision for an offense involving family violence while licensed, that the respondent must be revoked. So we come before you today recommending that the acceptance of the PFD and the revocation of the respondent's peace officer license. Thank you.
Sir, I know you stated your name previously, but if you could do it again, I'd
Back
greatly
for
appreciate
the
it.
record, Robert Rogers for Officer Roselle. So just kind of just to hone in on my argument on this, I filed exceptions to the ALJ's proposal for decision on December 4th, 2025. The heart of my argument is that Officer Roselle pled no contest to a different offense than what was originally alleged to have committed. He pled no context test to a completely different charging document, which stated that he no contest to disorderly conduct, which was fighting with another in a public place. And so another was not defined, fighting is not defined. And so the executive director and staff are relying on the use of extrinsic evidence to go behind the judgment itself to show that it's an offense involving family violence. And my argument is that I know that that has been used in criminal cases, in cases in where a person's been convicted of assault and they can show that there was a familiar relationship to try to prove some type of enhancement. And in a criminal case, you have to prove that beyond a reasonable doubt to get that enhancement at trial. What I question is the use of extrinsic evidence to take a disorderly conduct, which on its face, fighting with another in a public place, is not a offense involving family violence. Some of the prior administrative law decisions which have used extrinsic evidence, they use the Code Construction Act, and so then they're going beyond, I believe, the letter of the law, which should be, is the judgment itself, does it reflect an offense involving family violence? And I believe that the administrative law judge and the previous administrative decisions misapply the law by expanding it and allowing evidence beyond the actual judgment itself. And so that's my point of law order, is that the judgment that John Roselle pled to was no contest to disorderly conduct, fighting with another in a public place. I'd ask the commission to consider and vote on my exceptions to finding of fact 4, 5, 6, and 9, as well as my exceptions to conclusions of law on number 7, that he was not placed on community supervision for an offense involving family violence, and that his peace officer license must not be revoked. And so I believe that using extrinsic evidence takes the certainty out of what John Roselle knew what he was doing back when he pled no contest to this. And you're retroactively saying, no, we're going to treat it as family violence, even though the DA did not, the judge did not. We're saying it's family violence now. And I would ask that the commission to consider looking at it in a different way. And I'll have Officer Roselle to say a few words.
Good afternoon. Thank you for your time and consideration. I'm a Marine veteran from Mississippi.
Sir, could you state your name, please?
I'm sorry.
Sorry, I didn't mean to interrupt you or get you off track.
Yes, ma'am. My name is John L. Roselle III. I'm a Marine veteran from Mississippi. I have dedicated pretty much a lot of my life to public services. I had 2 years with the Sheriff Department back home, as well as 13 years with the Dallas Police Department. I want to speak casually here and say that I've made a lot of mistakes in my life. My biggest one was cheating on my wife. And since then, she has forgiven me, and we're now currently raising our 4-year-old beautiful daughter. I have never been convicted of family violence, and thank you for your time.
Commissioners, by way of a very brief rebuttal, the ALJ's analysis is correct. Our rules specifically say under 223.19 that TCOLE can revoke a license for any offense involving family violence. Those word choices are intentional, and TCOLE v. Grant and other cases illustrate that looking to extrinsic evidence to establish if the offense involved family violence is the standard that we call for in the state of Texas for peace officers. So for that reason, we concur with the ALJ, and we believe that the respondent must be revoked for an offense involving family violence and a conviction of that. Thank you.
Commissioners, what questions or comments do you have? Okay, absent any questions or comments, do we have a motion? Okay, I take it we need to discuss further.
I'll make a motion. Let me just get it correct. I'm gonna do it here.
I'm sorry, Seth.
I'll be making a motion. I make a motion that we move to accept the executive director's recommendation of acceptance of the PFD and the revocation of the respondent's peace officer license.
I second it.
Okay, we have a motion and a second.
Commissioner Kim Lamo,
Yes.
Commissioner Justin West,
Yes.
Commissioner Janet Atkins,
Yes.
Commissioner Justin Berry,
Yes.
Commissioner Connor Harvey,
Yes.
Commissioner Sergio Sines,
Yes.
Commissioner David Kreiner, Commissioner Jason Griffin,
Yes.
Commissioner Rita Watkins. All voted in favor, motion passes.
Okay, motion passes. Gentlemen, appreciate both of y'all being here today. Yeah, Mr. Roselle, happy for you that you and your wife are back together and you're raising your daughter, I believe you said, 4-year-old daughter. Wish you the best of luck with that and future endeavors. And again, very much appreciate y'all being here today. Thank you so much.
Thanks for your time.
Okay. So let me ask this group, do we need a break or do we push forward?
We just FYIs, I believe.
Okay, we are going to go ahead and move to Assistant General Counsel Haley Glisson.
Good afternoon, Commissioners. All of these actions have already taken place by statute or operation of law, so no action is needed by the Commission. I will just briefly summarize them. There were 9 statutory suspensions where licenses were suspended for 30 years due to the individuals receiving deferred adjudication for a felony offense. There were 9 statutory revocations where licenses were revoked by statute because they received a felony conviction. There is 1 licensee surrender for a term of 18 months, 17 permanent licensee surrenders, 12 reprimands for training noncompliance. And just to clarify, these are individuals that are now in compliance but completed their training after the deadline. And there were 2 reprimands for administrative violations. Thank you.
Okay, ladies and gentlemen in the audience, we're going to move to agenda item number 9, which is to receive public comment on any topic. I don't have any cards indicating that anyone else wants to speak, but you're welcome to come up, speak, and then we can fill out a card after the fact if anyone would like to come up and provide public comment. I don't see anyone rushing down the aisle, so we will move to agenda item number 10 and 11, which is executive session. And returning from executive session, we will not be going into executive session today. So we are going to move to agenda item number 12, which is to adjourn. And for that, we need a motion.
So moved. Second.
We have a motion and a second. All those in favor say aye. Aye. Any opposed, same sign. And before we we are back here tomorrow at 9 o'clock for The incumbent commissioners, we oftentimes start at 9:30 if we're in Austin, but we are starting tomorrow at 9 o'clock. So we will see everyone back here at 9, and we are adjourned.